Jonathan Price. I am here at Pusey House as a Matroshik Fellow and a Fellow of this college, St. Cross College, and our principal is Father George Westhaver here. And the third man in a Roman collar you might see running around, well, you might see more, but is Mark Stafford. He's the third member of our triumvirate that tries to keep this place going with the help of David Sten, John Ritzma, who helps here at the Center for Theology, Law and Culture and is a fellow at Oriel College, and other persons you'll meet throughout the day. Thank you for coming. I think we'll grow as the day goes on. This isn't bad for a 9:30 beginning. We have about 38, 39 people who've committed to come, and we're going to extract that from them, that commitment. We've signed a contract, as it were, with them that they'll show up, and then we have a nice dinner this evening in the hood room. If you need a smaller room, toilets, while this is going on, feel free to let yourself out and go down the stairs. There's a door on your right where there are two inside. You won't believe it as you're going down the stairs that there's more, and once you get to the door that there's even more, but it's there. If you go left, you'll get into our archive, and that's interesting, but probably not what you're after immediately. Last year we had a colloquium, and our mutual friend Pierre Gubaré was here for it, and he said, "Oh, I love what you do. It's great, it's great, it's great. Can we do this? Can we do this together?" And he said this to Father George, and we said, yeah, why not? And so here we are, about a year later, maybe a little less than a year later, doing a colloquium on liberty and natural law. Very briefly, and then I'll turn it over actually to our partners in this from the Revue de Philosophie de Droit. It's in Paris, yes. It itself is located in Paris, and to representatives of that august journal to tell us about it and its work, and about what might happen with the papers that are presented today. But law and liberty seem to pull in opposite directions. Haven't always, right? Certain understandings of liberty or freedom, or other words we use for them, are often synonymous with what one might mean by law-abidingness, right? The freedom to do the good. It's a classic way of thinking of it. But they tend to pull in such opposite directions that when we think of law, we tend to think of things that we're asked to do or that are demanded of us as a first, if not the denotation, as a connotation that comes along with it. And when we think of liberty, we think of lacking restraints, being able to, in Thomas Hobbes' phrase, to list where one pleases, right? To move about freely, to do as we will. Now, those are meager and small definitions, but they are construals that guide us in the way we think of the world and cause us sometimes to say, I'm for liberty and not for natural law or laws of nature, or I'm for laws of nature and therefore liberty is suspect. So we wanted to draw people together at the urging of our friends at the Revue to ask questions about the relation between these two, how consonant they are, under what definitions, and how some of them have worked themselves out within the legal, theological, political history of our civilization. That's a modest goal for today, but we'll try at it with this first session. And with that said, I'd like to turn this over to Roger Bailda. I've ruined, where is he? Where's Roger? Who's going to speak on behalf of Pierre Gubaré, who can't be here, about the Revue, its work, and what you hope to accomplish through our partnership. It's my understanding of what will be said. If that's not what you will say, then it's wholly my fault. So, shall I turn this over to you, and then he'll introduce the session.
Well, good morning, ladies and gentlemen. My name is Roger. I teach constitutional law at the law school, and as Jonathan said, I am here to deliver a few opening remarks on behalf of Pierre Gubaré, who unfortunately wasn't able to join us today. So let's get started, shall we? Dear Jonathan Price, dear friends, the Revue de Philosophie de Droit is delighted and honoured to be able to hold its first conference in Oxford. Our next colloquium will be held in France at the Assemblée Nationale and then at the Sorbonne, but Oxford remains Oxford. It is a benchmark for legal philosophy, and I personally had an excellent time here 2 years ago. The Revue de Philosophie de Droit, although very recent, is the only academic journal of natural law in France. Since jurisprudence is not taught in law faculties, students are not familiar with the great figures of natural law, but they know Carlson by heart, which is why we will be publishing translations, the proceeding of this colloquium of course, but the first issue includes a translation of an article by John Finnis, previously unpublished in French. The creation of a new academic journal, especially in paper format and in the philosophy of law, may seem like a challenge. Journals are tending to disappear or to replace paper format with digital format. The paper format is a guarantee of quality. The screen acts as a screen, and, regardless of the content, a paper journal avoids the pitfall of being confused with a blog or a website. These days, philosophical analysis of the law are limited in scope, so much so that legal positivism reigns supreme and axiological neutrality is monopolized when it comes to commenting on the law. Our ambition is to present an alternative to legal positivism, which alone has the right to be quoted in all the other academic journals. This because legal positivism presents itself as the only scientific conception of the law, as if a proper analysis of the law should shield it from any metaphysical or philosophical dimension. Positivists do not conceive of positive law as a part of a greater whole, but as the whole itself. Either you are a positivist or you're not a lawyer. However, other versions do exist and deserve to be heard, or rather read, and we are creating this space for dialogue and reflection for those who do not share the idea that discussing the law presupposes, or even requires, that one's analysis be sheltered from any economic, political, religious, ideological, or other conception. The idea that what is unjust is not law has been replaced by the idea that the law is what is instituted by an authority in a given system. There is no longer any reference to the content of the law or its purpose, but simply to its binding dimension. Instead of the law just as a, quote, science of the just of the unjust, the idea is, unquote, that law is an effective norm that has followed correct procedure. This seems to us to be an unprecedented impoverishment. It is time to put a finalist approach to the law back into people's minds, on university benches and in libraries, as opposed to the procedural vision of the law. By the way, in French, right and law are the same word, so by definition and by etymology, what is law is what is correct, not only procedurally, but also substantively. The mere conformity of a standard with a higher standard seems to us to be an insufficient criterion for describing a standard as legal. Similarly, we do not believe that the fact that a norm is effective necessarily makes it legal. The aim of the journal is not to describe the law in force or to be a kind of true photograph of the state of positive law, but to take a philosophical approach to contribute to the analysis of the law and to the training of lawyers, with a particular interest in students. As the law is first and foremost a practice and only becomes theoretical by accident, we will call on the writings of practitioners who are in the best position in the exercise of their art to find what is right. All these considerations have led us to set up an international scientific committee with professors from 4 continents, representatives from Harvard and Oxford, and a deliberate mix of privatists, publicists, legal historians and practitioners, judges and lawyers. Positivists who don't want to include politics in law have a specifically political objective, which is to exclude natural law from the field of what they call law. What if it was the other way around? What if it was the ideological positivists, to the extent that they do not include any notion of justice or fair proportion in their definition of the law, who are not practicing the law? Having the name of law is not enough. Yet you also need to have its content. There is nothing scientific about parroting when it is necessary to comment on the law in force. Reduced to its coercive aspect, the law is indistinguishable from other types of violence. We're all familiar with St. Augustine's dictum that without an idea of justice, there is no difference between law and the charter of a gang of thieves. No one denies that the formulation of a legal norm is the result of a will. We can only hope that this will is prudent, informed and balanced. Law is not only a work of will, it is also a work of reason. We hope to add reason to legal analysis and production. The 1789 Declaration of the Rights of Man and of the Citizen, which has had constitutional status in French law since 1971, states, and I quote, "Freedom consists in being able to do everything that does not harm others. Thus, the exercise of the natural rights of each man has no limits other than those which ensure the enjoyment of these same rights by the other members of society." Unquote. Alongside the right to own property and the right to resist oppression, liberty was classified as one of the, quote, natural and imprescriptible rights of man, unquote, at the time of the French Revolution. we sometimes read that while freedom is a principle of natural law, responsibility, is a principle of natural law, responsibility, its corollary, is a principle of social order. As good jurists, we believe that social order is founded on the Constitution. And so, therefore, I think this leads us, or rather leads me, to giving the floor to a constitutional law scholar, Clemente Recabarren, to give his presentation. Thank you very much.
I neglected to do something which I should have done earlier, and that is to introduce the speakers. And we tried to figure out this dance just before coming in during the coffee to put everything back together, and we've just about got Humpty Dumpty back together again, right? Clemente Recabarren does something at Oxford that no one else does. That is, he convenes. Yeah, it's true. It's true. He convenes a Fortescue, a reading group at the Canterbury Institute, which is where the preeminent young and not as young anymore minds in Oxford jurisprudence come and read books together. And some of the people in this room, Howard, Paul, others, Mariana, I see, all are part of that group, and it's really adding a lot to the discussion. Things that aren't easily done inside the university formally anymore, that just should be done. And that's a bit of what we try to do here as well. Do what the university used to do well, maybe even try to do it better. Clement is at St. John's College, where he is just about to complete his work on his doctoral dissertation. Isn't that correct? He's one piece of lead away from doing that. And he is an expert on constitution making, and what we should or should not do with and for them. After Clemente speaks, we will have Professor Sébastien Neuville, who has two professorships at Toulouse Capitole and at the Sciences Po in Paris. And he's the scientific director of the Revue that you just heard so much about from Richard. So thank you so much. We'll go directly to Clemente, and when you're done, then to you, Professor Neuville.
Excellent. Thanks so much. Thanks so much to all the organizers for the invitation. This presentation gave me the opportunity to put in order some thoughts that relate to my work, but that I haven't had the time to kind of go through properly. So I'm grateful for that. Okay. In contemporary constitutional theory, it is often thought that the legitimacy of constitutions depends, at least in part, in their ability to secure democratic self-government. I think there is much of truth in this view, and that the natural law tradition is fully equipped to explain and illuminate that sound judgment. In a way, the natural law tradition has been doing just that for centuries by expounding on the wisdom of mixed constitutions. For the same reason, however, the natural law tradition is well placed to diagnose distortions of the relevance of democratic self-government for constitutional legitimacy. And we can also find such distortions in contemporary scholarship. One such distortion is what I'm going to call the theory of constituent power, by which I mean the claim that democratic self-government in constitution making is either necessary and sufficient or just necessary for legitimate constitution making authority. This distortion has been endorsed by scholars and has had some limited impact on adjudication. So courts have resorted to it to endorse extra-legal constitutional change on the grounds that the relevant changes were brought about by the people exercising their constitutional power, and has also been used by courts to prevent otherwise lawful constitutional amendments on the grounds that they were not brought about by the people exercising their constitutional power. What I want to do today is to explore two strands of natural law thinking that have endorsed this distortion, or at least some of its underlying premises. Before that, I'll briefly define some terms, and I'll offer a view of what I think is the place of self-government in a sound account of constitution-making authority. The two natural law approaches that I want to discuss deviate, in some regards, from what I take to be the sound account. Okay? Definitions. These definitions are quite standard, but I think it will be helpful to have them in mind as we proceed. Okay? So I take authority and promising to be normative powers. Okay? To use the language that Joseph Rust made popular among legal scholars. A normative power is the ability to change the normative situation by communicating the intention to do so. It is performative. Authority is a normative power to impose duties on others, and the power to promising, is a normative power to impose duties on ourselves. I use duty and obligation interchangeably to refer to that which we are in a rational necessity to do. This necessity, however, need not be absolute. A duty or an obligation may be divisible. Okay? I use legitimate as synonymous with legitimate authority. An authority is legitimate if its directives, the communication of his intention that you should do or not do certain things, generates a duty for you to do or not to do such a thing. To speak of the legitimacy of a constitution is just a shorthand for the legitimacy of constitution-making authority. If constitution-making authority is legitimate, we have a duty to do as the Constitution says. The question of constitutional legitimacy then is a question of the practical reasons that warrant a duty to obey constitution-making authority. The distortion that I have called theory of constituent power contends that for a constitution to be legitimate, it must recognize the authority of the people to make and unmake its constitution. In its strong variant, it claims that this is all that is needed for constitution-making authority to be legitimate, and in its weak variant, it claims that this is just one necessary condition for legitimacy. This latter weaker variant will be my focus here. The two strands of natural law thinking that I want to examine and criticize are closer to the weak variant, and both would reject the strong variant of the theory of constituent power. Okay? One last preliminary. What is exactly for people to exercise constitution-making authority? I think this is a difficult question, and I don't think theories of constituent power have a good answer to it. But it's not the problem that I want to focus on today. The standard form of their claim is that constitution-making authority should be exercised democratically, and that when this is so, we can assume that the people have consented to their government in the sense that they have promised to obey. Okay? So that's for the definitions. Okay? Now, what I take to be the right account of constitution-making authority and how it relates to self-government. What grounds legitimate authority is the capacity to secure coordination for the common good. Human communities need authority in order to secure fundamental goods, common defense, prosperity, protection of life, promotion of culture, and so on, the ensemble of which we call the common good of a political community. We have a duty to secure the common good of our community, and whenever obedience to political authority is necessary to that end, we have in principle a duty to obey. Obedience is just one way, amongst others, in which we can fulfill our duty to secure the common good. I think you will all be familiar with this view. It is, I think, the traditional natural law view, and I think you will also be familiar with John Finnis's account, in which authority is presented as a solution to coordination problems, on which I will rely. Now, constitution-making authority, I think, is a species of political authority. It contributes to the common good by settling authoritatively who is to exercise authority in the community and framing the exercise of authority in its fundamental aspects. It thus gives a community a standing plan to coordinate its action in response to its standing need for authority. The need for authority is continuous because the common good is inexhaustible, and coordination and arrangement that secure the common good need to be sustained over time, adjust to ever-changing circumstances, and corrected in its deviant aspects. A constitution then is a rational response to this continuous need for authority. This makes the constitution a central aspect of the common good, so that in principle, and in the absence of a constitution, authority is to be exercised by whoever has the capacity to secure the common good. Once there is a constitution in force, the common good requires that we should obey only constitutional authority. Say, obviously, very powerful reasons to the contrary. Now, there are both intrinsic and instrumental reasons for democratic self-government. Democracy offers citizens the opportunity to deploy their agency in the pursuit of the common good, and under many circumstances, it reinforces their willing cooperation in the coordination arrangement settled by authority. Generally speaking, democratic self-government is an important aspect of the common good and a necessary condition for a constitution to be the best it can be. However, democracy enjoys no lexical priority over other aspects of the common good, and it is conceivable that the common good may require coordinated action that is incompatible with democratic self-government. Democratic self-government then is not, strictly speaking, a necessary condition for legitimate political authority. It is always the case that the constitution that we ought to obey is not the best it can be, and under certain circumstances, it may be the case that the constitution that we ought to obey does not secure democratic self-government. This view, as it should be plain, relies on contingency, on the contingent circumstances that may make it the case that authority is legitimate but incompatible with democratic self-government. Important as it is, however, we should not emphasize contingency to the point of neglecting the value of the democratic self-government. As soon as it is reasonable, in light of the other demands of the common good, authority has powerful reasons to allow citizens to share in the exercise of authority of their community. And there is, of course, no sense in which democratic self-government is sufficient for legitimacy. Okay, the view that I have just sketched, I think, is an elaboration of premises that are well established in the natural law tradition. However, there are voices in the natural law tradition that take a different view. In close parallel to a theory of constituent power, some in the natural law tradition have thought that the people enjoy a fundamental power to establish their political regime. Crucially, these voices think that the exercise of this power by the people is not qualified by other aspects of the common good, but a self-standing, independent requirement. Okay? And I want to offer you two such approaches. First, there is the idea, which I think it is fair to attribute to Grotius, that at the root of political obligation, for example, of the duty to obey constitution-making authority, there must be an act of will, specifically a promise, by those subject to authority. The view that authority have its foundations on a promise is generally alien to the natural law tradition. But Grotius seems to offer a way of reconciling these two ideas. There are standards of natural law, he acknowledges, and they establish the limits of what we can do. Within those limits, we enjoy an inner power, a natural liberty to do as we please. And it's by exercising that freedom that we come to be under obligations. Promising is one way in which we can exercise that freedom, and it is especially apt to generate obligations because it signals the intention, the choice of so doing. This understanding of the grounds of the duty to obey political authority, I think, is mistaken. And it mistakes both the grounds of promissory obligations, and it also misses that the opportunity for exercising freedom that promising offers depends to a large extent on there being political authority, on there being authoritative coordination arrangements. Okay? And I'm going to try to explain these 2 points. First, on the grounds of the promissory obligation. One problem with this view is that it cannot explain where our duty to keep a promise comes from. The duty to keep a promise cannot be grounded in a promise or in any other exercise of freedom. The idea that we bind ourselves by promising presupposes that we have an obligation to keep our promises. Where does that duty come from? For Grotius, the underlying assumption seems to be is that we have a power to create obligations out of nowhere by will. But the assumption that free choice is a self-standing explanation of obligation, I think, is very implausible. As Russ argued, and as Joseph Russ argued, and I agree, a normative power exists only if it is all things considered desirable that someone can bring about a normative change by communicating his intention to do so. The implication of this test, which Russ calls the basic justification test of a normative power, is that any normative power must be justified by reference to reasons, to what is all things considered desirable. Therefore, there are no inner normative powers that we have independently from their underlying moral justification. How can promising satisfy this test? I think this is an interesting question which I shall pass over, except to say that I largely agree with Elizabeth Anscombe's argument that the duty to keep a promise is valuable because of the cooperation that the practice of promising enables. That seems to me the argument about the value of the practice, the way for promises, for the normative power to promise, to satisfy the normal justification test that Russ offered. Okay, so 2 conclusions can be drawn from this. First, freedom offers no self-standing justification for promissory obligations. Second, promissory obligations are grounded in the reasons that make it the case that under certain circumstances it is valuable, good, that we can undertake obligations by so saying. These 2 conclusions pose a challenging question for anyone who, like Grotius, wants to explain legitimate authority as resulting from a promise and remain within the natural law tradition. The question is, what reasons could justify making the common good, which we need a political authority to secure, dependent on one's or anyone else's choice. Once we consider the fundamental goods that political authority makes possible, I think it is just plain that we have a duty to secure them independently of whether we promise to do or not. I presume that if Grotius were to abandon the assumption that the will can create obligations out of nowhere without reason, he would point us to the value of freedom and say that making authority dependent on a promise is a way of securing freedom. But this argument, I think, will not do. One reason that it will not do is that the freedom that we can exercise by promising can only fully be taken advantage of if it is coordinated and sustained by political authority. By contrast, a practice of promising without authority, although possible, would offer a considerably worse opportunity for exercising freedom. Just for clarity, let me repeat this idea. The claim is not that without authority, no promising is possible. The claim is that authority greatly enlarges the scope of freedom that we are able to exercise by promising. Okay? Now, consider, just to substantiate this claim, consider how the practice of promising is coordinated and sustained over time by an authoritative plan that directs the actions of those who engage in the practice of promising. This plan involves two elements, or at least two elements. On the one hand, it involves power-conferring rules, okay? A term that was first introduced by Hart into legal philosophy, but that has more recently been fruitfully expounded in Marius Kopke's work on legal validity. As Kopke explains, the function of power-conferring rules is to authoritatively specify the means through which we can exercise normative powers, for example, the power to promise, so that the normative changes that we effect by exercising those powers are valid, which means two things. First, they are marked, that is, made salient as exercise of an authoritatively recognized normative power, and thus, second, able to circulate, that is, be known and treated by others as making the normative difference that the exercise of the normative power was intended to make. Kopke argues that this technique of marking and circulation is at the root of contracts, wills, incorporation of companies, charities, credit cards, airplanes, train and bus tickets, and so on, all of which are said to be valid because they were brought about in the authoritatively recognized way. At the root of all of them, of all these things, valid things, we will find people exercising powers, crucially promising, and that the effects of such choices, of those exercise of powers, reach far beyond what they could have individually secured or even anticipated. All this is made possible by the authoritative plan that coordinates the practice of promising, thereby greatly enhancing those people's freedom. Note incidentally that an important function of any such plan, although by no means its whole point, is to withhold authoritative recognition to some promises that cannot have been made for a valuable purpose. The second element in which authority will support the practice of promising is that this authoritative coordination plan sustains the practice of promising over time by making provision for the coercive enforcement of promises made through the authoritatively recognized means. Coercive enforcement makes the benefits of this institution widely available and sustains it over time by punishing and preventing free riders. The need for this authoritative plan entails the need for someone to exercise authority in introducing it, adjusting it to changing needs, and correcting its deviant aspects. This need for authority is continuous, among other reasons, because the practice can be only fully taken advantage of by sustaining it over time, thereby allowing its participants to join in valuable projects that may long precede their time or carry on after they have passed. The opportunity for the exercise of freedom that this practice offers for oneself, one's family, and one's community warrants cooperation in establishing and sustaining it, and not undermining it by free riding, all of which entails obeying authority. It would be unreasonable to refuse to do one's part on this very valuable project because one has not promised to do so. Note, finally, that for ease of exposition, I have isolated the practice of promising from other goods that a community secures through authority. But they are deeply intertwined. The practice of promising makes possible valuable projects for a community, and the authoritative plan that coordinates and sustains this practice is part of a wider plan in which the practice of promising is coordinated, that is, incentivized, prohibited, subject to special requirements, given varying degrees of autonomy, and so on, with the various dimensions of the human good that a community seeks to realize. Okay? And I think these two elements, these two ideas, are totally missed in Grotius' notion of natural liberty. The idea that the grounds of the promissory obligation presupposes a natural duty, and can only be explained by reference to the goods that the practice can achieve, and second, the way in which the existence of authority supports and enlarges the opportunity for freedom that promising makes possible. Okay? Now, a second strand of natural law thinking that has come close to the theory of constituent power recognizes, in line with Aquinas, that our duty to promote the common good arises independently of any promise. But, they say, political authority must still be transmitted by the people. Unlike Grotius, this view purports to ground the duty to obey in the common good, while maintaining that the determination of who and how is to exercise authority for the common good corresponds to the people. I think that this compromise is untenable, okay? And I'm going to try to explain why. According to a widespread interpretation, and here I'm closely following Roger's thesis on Vittoria and Suarez, Vittoria's and Suarez's reflections on political authority exemplify the view at hand. So expanding upon a preceding tradition, Vittoria and Suarez conceive of the people as endowed with an inner power to establish their political regime in a constituent act, the Pacto Subjectionis. The point of this pact is to establish the constitution and transmit political authority to a person or subgroup of the community. At the same time, however, and this is what introduces the tension that I'm interested in, they thought that life in a political community, which as they acknowledge entails obedience to political authority, was a requirement of natural law. Both thought that the people have a duty to secure the common good of their community, including by obeying political authority. And both grounded the powers of authority, including the power to bind in conscience by legislation, directly in the common good. If, as most interpreters argue, this doctrine of transmission is aimed at identifying a condition for legitimate political authority, the tension between this doctrine and the duty to secure the common good, I think, is apparent. Confronted by an assertion of authority that is required for the common good, but not authorized by prior transmission, one may obey or withhold obedience. If in any such a scenario, the right thing to do is to obey, then transmission is not required for legitimate authority. On the contrary, if in any such scenario, the right thing to do is to withhold obedience, then the duty to secure the common good is not enough to justify authority and can only be one can legitimately hinder the common good by withholding obedience because authority was not duly transmitted. This latter position, I think, is incompatible with acknowledging a duty to secure the common good. It amounts to endorsing the possibility that one might legitimately choose to hinder the common good because one didn't transmit one's inner power. A duty, I take it, need not be absolute. It may be overridden by conflicting considerations. But in no plausible interpretation of duty does the absence of prior authorization by the duty bearer count as a consideration that overrides the relevant, allegedly pre-existing duty. In other words, to require prior authorization is simply to deny the existence of the relevant duty, even if one acknowledges that once authorization is given, it operates as a promise and results in a duty. So, a contemporary proponent of this view is Joel Alicea, and he has offered an attempt to ground the authority of the US Constitution in popular sovereignty. So, closely following Vittoria and Suarez, Alicea holds that the people have a duty to live in a community and to pursue the common good, which necessarily entails that someone must exercise authority. So far, so good. As Alicea understands it, the principle of popular sovereignty entails that the people are vested with ultimate political authority, which they exercise by, and I quote, which they exercise by establishing, and here I quote, a definite form of their choice. His argument in support of this view is the following, and I quote again. Because political authority is necessary to achieve the common good, it is vested in whoever has responsibility to achieve the common good. and everyone in a society has a responsibility to achieve the common good. Thus, everyone in a society is vested with political authority as an original matter. This argument, I think, relies on an unwarranted inference. From the fact that everyone is responsible for the common good, it simply does not follow that everyone is vested with political authority. To exercise authority is to perform a special task in a common project, for example, establishing a new constitution. But shared responsibility in a common project is perfectly compatible with, and almost invariably requires, different tasks in realizing that project. The responsible citizen that defers to authority for the sake of the common good is in fact sharing in authority in a fundamental but modest way. He understands that his role in the common project is different from that those in authority. Moreover, he understands that given that he has responsibility for the common good and that deferring to authority is required if he is to fulfill that responsibility, it would be unreasonable to make his contribution in the project conditional on his own consent. Rather, the responsible citizen understands that he ought to consent, and therefore that his consent is not what makes authority legitimate. Alicia's argument, just like the argument often attributed to Vitoria and Suarez, presupposes that there is a sharp discontinuity between the conditions that ordinarily make political authority legitimate, that is, coordination for the common good, and the conditions that make constitution-making authority legitimate, that authority is transmitted by the people. But there is no such divide. Alicia's point that the common good will rarely be achieved by direct democracy applies with the same force to constitution-making authority and to other aspects of the common good. The constitution is a fundamental part of the common good of any political community, and that, and not the transmission of an inner power, is what gives us reasons to obey it. To conclude, I'll just like to note my disagreement with Jonathan Price's initial framing of law as opposed to liberty. Any assertion of authority confronts us with a choice to obey or withhold obedience, and that is a free choice. If one recognizes a duty to promote the common good, and that in the relevant circumstances obedience is necessary to secure the common good, then one should obey, save powerful reasons to the contrary. That one did not consent, choose, or transmit one's power is not one of those reasons. To treat lack of any of those, lack of transmission, for example, as a reason to withhold obedience is simply to deny the duty to secure the common good, or that obedience is necessary to that end. Thank you so much.
Would you like to, Professor Neuville has asked to speak from his seat, and it is permitted here in Pusey House where we have great liberty.
Thank you.
And many obligations.
So, thank you very much. So I want to begin to apologize because my English is very bad and my accent is terribly French. So I will try to not to be too bad. I'd like also to start by sincerely thank the organizers of this conference. It's a great honor for me to speak at Oxford University on Pusey House. So the title of my conference is in the paper. It's written "Free Will and Legal Determinism," but it will change a bit because it's more than free will and determinism. What legal consequences? Because it's a problem of if we have free will or if we have determinism, what are the consequences in law? So, before getting to the heart of the matter, I would like to make two comments. The first point is that the passion of freedom is a characteristic of our time. But Benjamin Constant, French, draws a distinction between the freedom of the ancients and that of the moderns. The hallmark of Greco-Roman antiquity is political freedom. The hallmark of the modern era is individual freedom. And we can ask something, hasn't there been a new development since Benjamin Constant? For the vast majority of people, freedom corresponds to free time. I am free only when I can devote myself entirely to myself, making freedom one of the characteristics of individualism. My second point is that the notion of freedom, according to the philosophers and to the jurists, is not exactly identical. For philosophers, it is more about the question of free will versus determinism. The question is whether we are intrinsically free. A priori, all philosophers agree that it is better to be free than not to be free. But for them, the question of free will and determinism is a very difficult one, especially as it is impossible to prove free will. First of all, this question is extremely difficult to answer. Thus, for Leibniz, this question is like a labyrinth. For Jung, it's a thorniest question of metaphysics. According to Kant, the problem of free will causes great embarrassment. For Schopenhauer, this is one of the deepest and most serious problems of modern philosophy. So, this question is extremely difficult to answer, and added to this, it is impossible to prove free will. For Descartes, the freedom of our will is known without proof, but the mere experience we have of it. According to Kant, the concept of freedom forms the keystone of the entire edifice of a system of pure reason and even of speculative reason. Certainly, freedom may not be known, but its reality is proven indirectly by the moral law and tested by the respected spies. So it is more an act of faith. We cannot know what freedom is, but we know that we are free. It is then possible to provide a definitive answer. Man, in his bodily dimension, is subject to the laws of nature and is therefore not free. But is he also determined in its spiritual dimension? Indeed, it is always possible to find a posteriori causes, explanations, family origins that can make us think that we are determined. Thus, for Bergson, it is always determinism which seems to be right. Science, language, common sense, the whole of intelligence is at its service. Any definition of freedom gives reason to determinism, but all determinism is refuted by experience. So, for philosophers, the question is a very great difficult one, especially since it is impossible to prove free will. What about for jurists now? For jurists, freedom does not seem a priori to be synonymous with free will. It is as if jurists and philosophers were not looking at the same reality. However, jurists also praise freedom, especially French jurists and French people, liberté, égalité, fraternité, you know. For some, freedom is prior to law, in the sense that law makes it possible to guarantee the exercise of freedom. In this first sense, freedom predates any legal recognition. For example, the declarations recognize fundamental freedoms that predate them. The declarations do not create such freedoms. For others, freedom can only exist because the law allows it, in the sense that the law creates freedom as liberty. In the second sense, freedom is enshrined in law and is formulated by the legislator in the broadest sense. Thus, since philosophers and jurists do not talk about the same freedom, the aim of this lecture is to consider how the philosophical question is important for jurists. What is the legal consequence of man having free will or being determined? For development, three situations can be considered. For some, man is purely material. For others, he enjoys unfettered freedom. For still others, he is a creature. First, man is purely material. The first materialist philosopher was certainly Democritus. According to him, everything in man is material, even knowledge. Knowledge is reduced to sum of atoms. He is thus an absolute materialist. However, such a vision was not widely shared in antiquity, but it reappears with Hobbes, then with positivism. Obviously, at Oxford, Hobbes must be spoken of with a certain reverence, especially since he was admitted to this university at the age of 14. Jurists especially retain the distinction between the state of nature and the social part. But his philosophy is materialist because, according to him, reason perceives in the universe only bodies whose properties can be explained by movement alone. In other words, by a universal mechanism that explains everything, whether physical or even psychological. Does freedom exist in Hobbes' system? According to him, freedom is defined as the absence of constraint, the absence of opposition. However, as with all movement in the universe, human psychological activity is subject to the laws of mechanical determinism. Free will is therefore an illusion, a mere word designated to hide the fact that we are not the masters of our decision, but that they have other causes. Hobbes plays also a very important role in the development of positivism. Positivism should be seen above all as a state of mind resulting from the relentless progress of science and an aspiration to autonomy from the spiritual. Its origin is found in particular among free thinkers. They developed materialist doctrines based on universal mechanisms. Here are just a few examples. John Toland believes that thought is simply a modification of the brain. David Hartley believes that ideas come together because of the vibrations of an ether that is contained in the sensory organs, the nerves of the brain. Lametri, Helvetius also has the same ideas. Later, with Auguste Comte, scientific thought became more theorized. But it is Marx who will make the link between materialism and determinism. For him, the only reality is matter and its forces whose continuous and progressive evolution explains the universe. The reality gives rise to human societies and civilizations, so that the development of humanity is subject to determinism. Thus, free will is a bourgeois luxury. For Freud, it is the unconscious that dominates consciousness, and he wants to analyze it scientifically. But to assert that the unconscious prevails, it is to call into question man's freedom, his ability to make conscious choices. Thus, when Oedipus violates two taboos, parricide and incest, when he learns that he is a criminal he is looking for, he shows that he has no freedom in his actions. For Freud, all men are Oedipus, subject to determinism. They have no freedom, so laws must be imposed on them. Consequently, according to materialism, man is a mere link in the great chain of causes and effects. And if we could master all the motives for an action in advance, could we predict it? Could we find out who is predisposed to commit criminal acts? It was Lombroso's theory of the born criminal that effectively denied any possibility of free will. In this way, man can be perceived as purely material, but for others, man enjoys unfettered freedom. So the second, man enjoys unfettered freedom. What barriers are we talking about? Are these only external barriers or even internal ones? For Epictetus on Stoicism, these are external constraints. According to Epictetus, a free person is one who lives as he wishes, whom one cannot be forced, prevented, or coerced. For the Stoic, we must therefore detach ourselves from the external things that hold us in slavery and concentrate on our inner self, because freedom lies within ourselves. The free man must thus despite everything that is external to him, even his own body, which is a slave to fever, goods, ophthalmia, dysentery, the tyrant, fire, iron, and anything stronger than himself. A fairly similar conception is found in Rousseau. The natural state of man when he is alone is to be good, perfect, and happy. He is even fully free because he depends on no one. According to this conception, it is therefore possible to be totally free while being a prisoner or while being confined to bed. But isn't this a denial of the world and the others? For Hegel, this freedom, which is the withdrawal of consciousness into itself, is reduced to remaining in the empty place of its interiority. Indeed, man lives in society, in contact with others. How can he escape external constraints, and in particular the law? But we can go even further. For Sartre, we must also detach ourselves from our inner fetters. For him, freedom is absolute. Man cannot be sometimes free and sometimes a slave. He is wholly and always free, or he is not. Concrete man exists, while human nature does not. He is not determined by an essence towards which he must strive. His freedom is ultimately enormous. It is dizzying. To exist authentically, we must freely choose ourselves. To exist is to choose, but to choose continually. We are condemned to be free. No internal constraint can limit freedom. There can be no standards outside ourselves. We have to invent our own, which leaves us in a tragic void. So, is freedom without constraint, external or internal, even possible? For Plato, true freedom is mastery of the passions and obedience to reason. Kant evokes a light dove which, when in its free flight splits the air whose resistance it feels, might imagine that it will be even more successful in space empty of air. And Hegel considers that such freedom is the freedom of emptiness. Finally, freedom, understood as the ability to do what we want, is absolute servitude, a deadly freedom. Unlimited freedom is illusory, meaningless, arbitrary, and worse, incapable of law. And who only wants to do as he pleases is most often a slave to his passions. So, man can enjoy unfettered freedom, but can he be created? So, third, man is a creature. After the limitless freedom promoted by Epictetus or Sartre, how can we accept that man can be created? Man would therefore not depend on himself, but on a creator. And in this case, if he is created, how can creation and freedom be reconciled? This is a real paradox. Either I am created, but I am not free. Either I am free, but I contest my stature as a creature, which brings us back to Sartre, for example. However, a third possibility should be considered. Can I be a free creature? Also, two statements will be treated successively. I am created without being endowed with freedom. I am created with freedom. I am created without being endowed with freedom. It's divinity, fate, destiny, the logos who decides everything. There are two possible situations. Either everyone has a predetermined place in society, either the destiny of each person is predetermined. A predetermined place is assigned to everyone. This view is defended by Gnosticism, Manichaeism, and Spinoza. It's the opposition between, on one side, the spiritual of Gnosticism, who are saved, since they are perfectly initiated, the pure of Manichaeism, or the estimables of Spinoza. And the others, the materials of Gnosticism, the listeners of Manichaeism, or the unestimables of Spinozism. A predetermined destiny is assigned to all. Such a position was first developed by Islam. The Quran retains predestination, which can lead to fatalism, which in part denies human freedom. Thus, for Ghazali, God creates the being of creatures, but he also creates their action, leaving little room for personal freedom. He adds that God reserves the right to accomplish himself what man wants, regardless of personal merits. This position was defended later by Luther. For him, the man is a sinner and is condemned to this sad state. Even if he tries to acquire merit by behaving well, he remains in his sin. But there is a justice external to man, which saves him. Through the grace of Christ, all the defilements of the soul are as if covered with light. It is therefore not necessary to do works in order to be saved, because it is God alone who saves as long as man has faith. Luther thus rejects free will and prefers to speak of self-will, which is a form of predestination. We do everything by necessity and nothing by the effect of our free will, since the force of free will is nothing and can do nothing good without grace. Luther's goal is to affirm the omnipotence of God's grace while humiliating human pride. Calvin's approach is slightly different. His starting point is the same as Luther's. Faith is more important than works. To recognize the slightest merit in man would be to set oneself up against God. For him, it is God who sovereignly decides the eternal salvation of the nation of man. Doesn't such predestination ultimately lead one to take refuge in ataraxia? Doesn't this lead to indulge in all kinds of vices? The answer is no for Calvin. If man has faith, he is predestined for salvation, which leads him all the more to live heroically. If man is to behave well, it is not in order to save himself, but because he is saved, which entails a high moral aspiration. If man has not faith, or a weak faith, he still has a conscience that can discern good from evil. He therefore establishes a freedom that enables us to distinguish between good from evil, whereas he withdraws it for the fundamental act that leads to eternity. For Spinoza, man is subject to rigorous determinism due to his submission to the divine substance. All events are necessary manifestations of divine providence. Man, therefore, has the illusion of freedom. If he thinks he is acting freely, it is because he is unaware of the necessity which makes him act. However, for Spinoza, everything is good because everything is justified by necessity. And the true freedom of man consists of a constant and eternal love towards God. Finally, Nietzsche sees man as nothing more than a creature subject to chance and to forces beyond his control. Man is like a pebble thrown into the universe. Thus, all these authors consider that the creator is not free. But another statement is possible. I am created with freedom. The idea is that creation and providence are not irreconcilable with freedom. For Jacqueline de Romilly, it was only with Judeo-Christian thought that the idea of man's freedom in relation to God came to the fore. According to St. Paul, people are called to freedom. Man, being created in the image and likeness of God, is endowed with freedom. The greatest dignity of man lies in his freedom, which is neither diminished nor limited by divine intervention. The latter does not transform man without him. On the contrary, it gives rise to freedom by having recourse to human cooperation. Man therefore has a responsibility whether he seeks good or, on the contrary, whether he locks himself into error. Freedom therefore implies responsibility, which is essential from a legal point of view. Thus, for St. Augustine, freedom is the power to control our own actions. He wonders, however, whether freedom is not incompatible with divine foreknowledge. Indeed, eternity allows God to see all past and future events with certainty, because he is outside time. But for Augustine, this knowledge does not destroy freedom, because man always retains his free will. But what kind of freedom are we talking about? In St. John's Gospel, we read, "The truth will set you free." There is therefore a link between freedom and truth in the sense of divine law. Divine law is not a law that oppresses freedom. On the contrary, it is lex perfecta libertatis, perfect law of freedom. There is also a connection between freedom and obedience. However, today, obedience is not perceived as something positive. It seems to be opposed to freedom. This manifests the creature's refusal to be dependent on its creator, the aim being to take control of the distinction between good and evil. Man wants to attribute to himself a power which is that of his creator. He wants to believe that he only depends on himself and thus have the illusion of his independence and his total freedom. Consequently, the human consciousness wants to become the highest divinity, and this divinity has no revolts. It wants to acquire the power to dictate to itself its own conduct in a sovereign and independent manner. It is true that obedience without freedom is not worthy of the human person. On the contrary, the Bible is a kind of pedagogy of obedience, so that it is more intelligent and free. The affirmation also refers to St. Augustine: "Love and do what you want, dilige et quodvis fat." This means that who do good motivated by charity do not do so out of necessity nor obligation, but out of freedom. The quotation from Jacqueline de Romilly continues: "Certainly, it was only with Judeo-Christian thought that the idea of man's freedom in relation to God came to the fore. But," she continues, "it was only later than that this freedom was felt in its continuous course as a kind of creation of man by himself. Thus freedom, which was given to man at the moment of creation, as a crazy gambler is now created by man. As Chesterton wrote, the modern world is full of ancient Christian virtues gone mad. In conclusion, where does contemporary man stand? There are two trends. First, either he thinks he has no freedom or he is determined. It means if man is not free, he cannot be held responsible for his actions. He can receive neither praise nor blame, neither reward nor punishment. So why bother? Aristotle had already raised this argument, but considered it to be lazy. Calvin considers that predestination should not lead to taking refuge in ataraxia, or to indulge in all the vices because conscience knows how to discern good from evil. However, it is interesting to note that the concept of fault has been distorted by the creation from scratch of an objective fault that is not imputable, especially in France. Similarly, the development of no-fault liability and the creation of warranty funds tend to disconnect freedom from responsibility. Second, either he thinks he has absolute freedom. Man prefers to conquer his freedom on his own. He does not want it to be granted to him, first by God, for the sake of emancipation, and then by society. But in this case, how does the law manifest itself? Only subjective rights remain in opposition to each other. But while law should pacify the conflicts of society, law itself becomes a creator of conflicts. Thank you.
Well, Clemente fired the first shots, I suppose. In an internecine battle of the Fortescue reading group over Grotius. And then we got quite a treatment and I appreciated theologically inflected treatment of law, which is what's missing often from the conversation nowadays. Our little Center for Theology, Law and Culture was established explicitly to bring theology with an uppercase T back into the discussion. So thank you for that, Professor Neuville. I'll use my right and duty and the law actually of the conversant, whatever I am, the discussant, to ask a question of you, Clemente, since it was aimed directly at me in conversations we've had elsewhere. And I made a note of what I wanted to say. It's actually my lecture that I'll deliver later. Out of nowhere, you talked about out of nowhere, obligations out of nowhere. And then you said, Grotius, that there's no grounds to presuppose a natural duty. Two things that you had said, those are slightly taken out of context, but that Grotius wants to bring public order out of nowhere. I think that's true of certain Grotians. Maybe Thomas Hobbes, Locke sometimes acts like this, and certainly Rousseau seems to. But Grotius is really explicit, and I'll offer the quotes later, that our promissory powers are based in something that was a gift from God. So the ultimate foundation is creatures of God. He doesn't talk about it after it's assumed. It's a necessary premise. It's assumed, and then it becomes exiguous to his argument. That is, after it's committed to, it's not needed anymore. But I don't think it's out of nowhere. I would describe your reading of Grotius as a naturalistic reading of Grotius, which is possible, which has been done in the contractarian tradition. But I don't think it's what Grotius says either in his De Jure Praedae or in his De Jure Belli. And I want to just ask about that because, Grotius's criticism is that there is no common or good until we recognize it together. So assuming that there's some common good assumes something shared in advance already, and that there can be some agreement on the good. And the religious wars had taught him that very low agreement on the good was actually possible. That was a hopeless endeavor. He admired Catholic moral theology, but he thought it was too much agreement that was necessary in order to have unity of purpose and have a. So he asks, do we have something in us that God gave us that allows us to establish common community between us and shared goods? I think that's maybe a more sympathetic reading of what Grotius is trying to do. Now, Grotians have done different things, many different things, and international lawyers love to do all kinds of wacky things with Grotius, but I don't think that's what Grotius himself was doing. So I'd say you have a fair reading of Grotians and maybe a not as fair reading of Grotius himself.
Okay, thank you. Yeah, I don't know if it is worth it to make it like too exegetical, the debate. So the view that I have in mind is a view according to which natural law, call it like substantive standards of the right, of justice, whatever, set certain limits, like things that you cannot do, but they don't kind of, they're unable to explain or to provide for like a reason why one should do as promised. So the idea is the promissory obligation comes from nowhere, in the sense that it's disconnected from the underlying natural law principles that simply kind of set you the frame within which you can then like exercise your freedom and acquire obligations and so on and so forth. I think that is perfectly compatible with a theological explanation that that inner power may have been given by God. I didn't bring it up because I don't think it's really relevant to the point. The question is whether natural law can explain for why we have a reason to keep a promise. And if the explanation is we have this inner power given by God, that seems to me equivalent to saying that the duty comes out of nowhere. In the sense that by nowhere I simply mean that there are no substantive standards, there are no goods, like principles of practical reason, so to speak, that explain that we have that duty to keep the promise. I'm sure that there will be quotes in the treatise on the law of war and peace that like seem to be in tension with this idea. There are other quotes, especially like in the prologue, which like, this idea is pretty clear. So I totally, I accept that like the exegetical debate might be like more difficult than I'm like kind of portraying it here. But I think the substantive view is still there, especially in the prologue. And that view seems to me, I mean, that the claim that the duty to keep a promise is kind of created by will without having any connection to like the reasons that natural law give us to like do certain things or abstain from doing certain things, seems to me to stand independently of whether there is like a theological story about like how we came to have that inner power.
So I'll say some of this later. I think I'll respond implicitly, obliquely in the lecture later, but I would add one small thing that's important about Grotius that gives some reason. That is, he believes we have an innate desire for society with others. Unlike Aristotle or others in that tradition, unlike Rousseau, he thinks we seek it out, we like it, we're curious, and we want to have good relations with others, and that's built into us as well. But he does rely on a lot of things being discovered in each human and present in each of us. So that, I won't hog the floor now, unless, did you want to jump in on this point, or should we take questions from? We can take questions. Okay. Would anyone like to join the conversation? Please say who you are and.
My name is Fernando.
Fernando, and why you're here?
I am here because I'm a natural law fan.
Yes.
And I'm a student at this university as well. Clemente, thank you for your presentation. My question relates somewhat to what you were just discussing with Jonathan, but I don't know enough about Grotius, so I won't discuss that. And I agree that it is an intelligent move to not go exegetical on this. So I'm not sure I understand very well the foundations of the idea that promising can be stand independently from considerations of the common good. Is that another way of framing what you were just saying? When you were saying that promising is a self-standing notion?
And I would say promising is a way to get a common and a good, to manifest something that's both common and good.
I have a question in relation to this point, but I just want to know if it's correct, the framing.
Well, I think it could be like interpreted in different ways, but like many of the possible interpretations are fair, I think.
Okay, so one comment and one question of clarification. The comment is that when you were talking about it, it reminded me of Dworkin's notion of rights as independent from the public good or the general welfare and so on. And perhaps there are interesting points there in the parallel. I don't know if the parallel holds, but because I don't know the idea very well that you were suggesting. But in Finnis's critique of Dworkin, he essentially says that rights are an aspect of the common good rather than in tension with or independent of. But that's probably because Dworkin didn't have a notion of what the common good is. And the question is a question of clarification. Does, in your view, the practice of promising necessarily presuppose authoritative schemes? Or, no, not necessarily, just practical, it's just a practical like benefit that there is an authoritative scheme, but it's not necessarily conceptually or...
Yeah.
Okay.
I mean, in a way, the authoritative scheme kind of, to a great extent also, like relies on a pre-existing practice that arises independently of authority. The point is, when that authoritative scheme comes in, the freedom that promising enables to exercise is greatly enlarged. And I think Marius Skopje's work is illuminating in kind of showing how like the authoritative plan enlarges, you know, the scope and the effects of what we can achieve by exercising this power. And the point is, if Grotius' concern, or anyone, like whoever holds his view, concern is with freedom, with the need to secure freedom, then it makes no sense to make that scheme, which greatly enlarges freedom, conditional on a previous choice. You know?
So promising and, just one more point. Promising and authority are on a par, as it were, at the roots of the production of normative effects by intention.
Yeah, they can be on a par. Yeah. I mean, in a way, like there are like two sorts of normative powers. So they purport to achieve the same, and in that sense, there are two ways of doing the same, of achieving the same thing, and in that sense, there are evolution. Sorry.
No, it's not you. It's this. It's the circus. It's the circus outside. Clinton. Thanks, Fernando. Clinton, tell us who you are, if you would, and then you can ask your question.
Yes, I am Clinton Collister. I'm one of the researchers in the Center for Theology, Law, and Culture. In the theology wing of things, I'm finishing up a PhD in theology and literature and theological anthropology at Cambridge. I'm coordinator.
Can you speak up slightly, or maybe stand up, because this is not helping us.
I can project. So I'm an ordinated Wycliffe Hall and a doctoral candidate in theology at Cambridge. My question relates to what we're saying about human nature when we talk about the importance of the promissory powers that are given to us by God, as Jonathan and Grotius were saying, but also when we're claiming that these promissory powers make it so that humans can and should contribute to the common good, how does this relate to the introduction of saying no-fault divorce? And so if a society recognizes that this is part of human nature and these promissory powers, and they are necessary for humans to flourish and for us to pursue the common good, which of these sort of philosophical currents led to the dissolution of lifelong marriage contracts and the introduction of no-fault divorce? Like, what do we see going into that?
That is on the one hand there's promise keeping that becomes foundational to much of the modern justification of the political order. On the other hand, certain kinds of promises, like the promise of marriage, are now subjected to no analysis at the point of breach. So you can have no fault divorce, for instance, which would seem to fly in the face of the meaning of promise keeping and the authority of promise keeping as constitutionally foundational. So he asked, what do we say about human?
Yes, perhaps I could explain it better in French than in English, because it's very difficult to explain in English. But
the question was ultimately, where does some of these currents come from that on the one hand support contractarian promissory powers, on the other hand say contracts don't really mean what we say they mean, and they can be broken at will.
could you help me please to back your translation or something?
Oui, l'idée c'est de savoir d'où viennent ces bilans. D'une part, si c'est purement contractuel, ça peut être prise et puis d'autre part, on attend que ces promesses ne soient pas brisées.
Je comprends pas le rapport avec mon intervention. I don't really understand the question even in French, so it's a problem. But you understand the question in English? Yes?
Well, I think I understood. I think he was asking about where different visions of human nature, this other vision of human nature that allows for immediate breach of promises comes from. That's been part of the revolutionary inheritance as well. After the French Revolution and the Russian Revolution, the marriage and divorce, and I think divorce especially, could be gotten at the will of one or the other party, and even by mail. With the Russian Revolution, you could just mail a letter for. So this is a curious type of liberty,
Yeah.
but it also interrupts.
Yeah, like they want like a total liberty, to be totally free to not to be constrained by external law. So but there's a question: is it a true liberty? Is it a true freedom to do like this? It's
The simultaneous justification at the time of the Republic was based on consent of the people that they've promised to hand over the power to someone else. So there's two anthropologies that are competing at that time. Clemente wanted to jump in, maybe.
Yeah.
Yes, I just one thought came to mind that might be helpful. Yeah, something interesting about non-fault divorce is that it is usually introduced for the sake of securing freedom, but at the same time it deprives or like it takes away a fundamental freedom to contract like an indissoluble marriage, and I think that kind of tension or trade-off illuminates like a more general problem, which is that we cannot really reason well in practical matters with a purely formal notion of freedom. We need a notion of what freedom is for, what are the goods that give freedom its point, if we are to reason intelligibly about what freedoms should be promoted and which freedoms should not be promoted or secure or guaranteed and so on. I think the introduction of non-fault divorce is kind of illustrates that tension, that trade-off well. If you take a purely formal kind of freedom, in which freedom is totally indeterminate and there is no good that it kind of aims for.
Clemente, can we pause? Could we invite some people to come toward the front, because it just seems like we're not hearing one another. There's a front row here. We could. Is that all right? We have about 10 more minutes, and this is not going to stop, I think.
So just to wrap up the idea, that is that's a problem that is well illuminated, I think, by this freedom that you gain and the freedom that you take away by introducing non-fault divorce. And the underlying thought here is, well, freedom is just not like a self-standing justification for action in any sense. You always need an account of what freedom is for.
Thank you.
Go ahead. Yes. Would you tell us who you are?
Yes, my name is Henri Torrione. I am a professor at the University of Fribourg in Switzerland, of Professor of Jurisprudence and also Financial and Tax Law. I mean, I was, because now I'm I would have a question for you about common good and self-government. I understand that all your explanations are based on the idea that there is an obligation to obey if the authority is oriented towards the common good. But who decides what is a common good? And in connection with this interrogation, who decides? Is there a connection with self-government or not?
Okay, that's a great question because it speaks to a very widespread intuition. You know, that disagreement about what the common good entails kind of justifies or like gives ground to the importance of self-government or democracy, whatever. I think like the question of who decides, like it ultimately comes down to what you and I decide as citizens of our respective polities. And the focus of, I think the central question is where is the right way of reasoning how to decide on these questions. And I would also say that the question of who decides is unavoidable and inescapable, both for like in a constitution that like offers democratic self-government and in a constitution that does not offer democratic self-government. So even if the constitution,
No, I think you slow down.
okay, yes, sir. Even in a constitution that gives the opportunity for democratic self-government, someone, the Democratic Assembly or whatever, is going to take decisions as to what the common good requires, and the central question is, how do we justify those decisions? The fact that there is disagreement, or that we disagree about what the common good requires, is just like the starting point of our conversation as to what should be done. But it doesn't settle what should be done. That would be my, yeah.
We have two questions here. Conor Casey.
Well, just to comment on this, because this is,
Who are you?
I'm a lecturer at the University of Surrey in the law faculty. But this question comes up all the time in natural law circles, and I think there's kind of two levels you could answer it at. One at a sort of institutional, political level, who gets to decide within this polity how to do X, Y, and Z. But there's more general level about the common good as an ethical, moral, metaphysical level, and there the natural law decides. I mean, so the common good is just the good flesh and blood human persons living together, held together by thick relationships, partly law, custom, virtue, love. It is linked back to an anthropological account of the type of animals we are, what kind of circumstances make us flourish, what kind of circumstances make us flounder, and the natural law tradition that's accessible by reason. So at a high level, there are certain patterns and ways of life that are just out of bounds. Then there are many that are in bounds, but they need to be prudentially determined and specified in a community. It takes you down to the second level. And again, that's often a matter of prudence. As you say, there's no special priority for mass suffrage, electoral representative democracy. That goes against the whole point of the tradition. It could be particularly prudent, but monarchical government's fine, republics are fine. Whatever, that mixed government is prudentially preferred. But at that level, you can't ignore the objective anthropological account of what makes humans flourish, or the nature of the common good is not a sort of aggregate. It's not a sort of utilitarian thing. It is the good of individuals living together. So at a certain level, no one gets to decide. The natural law decides what the common good is, but at a sort of prudential, at a more regime level, that's a matter of sort of prudence. Lawmakers do most of it, judges adjudicate justice according to law and so forth. But I think it's very important at a certain point just to say no one decides.
That's very helpful. I really like the distinction between those two levels. I took the question to be like immediately connected to like, I don't know, this widespread intuition that the fact that we disagree is kind of an argument for the legitimacy or the necessary character of democracy or some kind of like a specific constitutional arrangement. But it is, I fully agree with the distinction and with its importance.
we have two more questions. Would you like to jump back in, and then it will be my microphone.
If I may
work away.
make a comment, I think it's very difficult, these two levels, because if you start with the obligation to obey, you start with a precise decision, concrete decision, so you are at the prudential level. And the issue is always raised when you are confronted with a practical decision in a contested situation. For instance, vaccination. We have gone through this. And it doesn't help if you have a good philosophical or moral definition of the common good. Everyone could agree with this definition of the common good and disagree with a concrete decision. So I come back. Is there another way than self-government? And I come from a country where we are very, for maybe mythological event in the past. It was the 13th century when we have the first federal pact, is called, 3 cantons, 3 different valleys in the mountains, with cows, not city, no big city among these 3 cantons, and they made this pact, which was based on the idea for our life, for our decision, concrete decision, we want self-government. We no longer want the emperor to decide for us. And they used in the Federal Pact, it was written in Latin, not common good, but public utilitas. Utilitas publicae. Probably it was someone coming from Bologna or with some, so is there another way than self-government to decide on a concrete matter of common good? I'm not sure. I mean, that there is another way that a radical democracy. It may fail, but...
So this is the Liechtenstein option, yeah? The Constitution allows any of the cities to leave.
I guess the question is there any other legitimate, like justified way of governing? Is that a question? Because like that there are other ways seems just plain out, like just out of like the observation of history. You know, there have been authorities which are not self-governed. Like there have been constitutional regimes. There are constitutional regimes which don't adjust or like fit or like fulfill this idea of self-government. And the question of whether that is the only legitimate way, I think it's no. Like we can all think of circumstances in which the common good is better served by obeying a single authority or whatever something different than a self-governing arrangement. So my kind of direct answer would be yes, there are other forms, and which is required is going to be a matter of prudential judgment, and that's what I think. I mentioned this briefly, but I think the fact that this is a matter for prudential judgment and therefore that is to some extent contingent shouldn't obscure that there is still something valuable in something valuable worth having in self-government. So that all other things equal, we should prefer self-governing arrangements. But one thing is the Constitution being the best it can be, and other thing is the Constitution that we have to obey in this limited and kind of real circumstances.
So, Michael, would you like to jump in and tell us who you are?
Yeah, I'm Michael Foran. I'm a lecturer in public law at the University of Glasgow. I think we're circling back to a central theme in both jurisprudence and constitutional law that's been operating within our wheelhouse for centuries at this point. And I think it's the interplay between will and reason. On the one hand, we have choices that can be made, institutional design questions that can be answered, who gets to decide. That's one of the core questions of constitutional law. It's the premise that constitutional law starts with. The other premise is when reason comes into the picture, which is what's off the table substantively. And both of those questions cannot be answered in isolation from each other. Those are central questions that happen simultaneously. And often within kind of liberal constitutional frameworks, we have no problem recognising difficulties around that in the context of fundamental rights, where we say, nobody says who gets to decide on rights questions as a fundamental stop to inquiry into constitutional theory. We recognise that's a question, and then we get into debates about whether the judiciary get to decide it, whether parliaments get to decide those questions. And we think that's fine. And nobody thinks the fact that we might disagree about the content, the substantive content of fundamental rights stops inquiry into that area. These are themes that have to run together concurrently. And so it's interesting that when conversation shifts away from fundamental rights questions, where those questions are raised and expected to be answered as a part of constitutional deliberation, and into something like the common good, suddenly those questions become serious roadblocks to constitutional theory when they would not be in another area. And the answer, I think, is that you have questions around institutional design, about prudence, and you have substantive points at which things are off the table. And the point at which those two run headlong into each other, I think, is circumstances where someone might be considering the regime no longer to have legitimacy, and so civil disobedience is on the table. Civil disobedience doesn't come because someone is unhappy with the way a decision was made. Civil disobedience comes because somebody takes a fundamental substantive disagreement with the outcome of a constitutional decision. And what they're arguing at that point is to say, I no longer have a moral obligation to obey the law because it's unjust.
Yeah.
And that is down entirely to, in a natural law framework, the idea that this is not compatible with the fundamental precepts of natural law. And that's a substantive point. It can't be about the form in which the decision was made.
So thank you. We'll put a pin in that we'll pull out later, and we'll say this: we don't really have Q&A. We have discussion, as you're seeing, and that's the way it's meant to be. If we could, ideally, we'd have a large room where we could all be in a circle and look into one another's eyes and challenge and affirm one another in that order. And then repeat the trick. But that being said, some of the points that were made in Professor Neuville's talk will come up later in Nathan's. And so if questions emerge about determinism, voluntariness, and other things like that, you can also ask questions of earlier speakers or have discussion with them during later discussion. That's why we do it as discussion, not Q&A. And the order of the day is what it is. I think probably had we then had a God's eye view of this, we would have organized it slightly differently to allow for those to come together at the same time. But that being said, you are free throughout the day to ask questions about anything that's come before during the day. We have coffee again in the same room. We'll try to get our time back, so we'll come back here as scheduled in the program at 11:30 to begin the next session with Professor Torrione. And me. Yeah, I'm sorry, you have to hear more from me before I shut up, basically. begin the second session of the day, which I probably shouldn't be introducing since I'm a speaker, but since I've already started, I'll just persist. I want to tell you just something very quickly about this room. Dr. Pusey, whom the house is named after, was one of the leaders of the Oxford movement, which is responsible for restoring much of the good of things that we've inherited to modern life, liturgically, architecturally, and in the curriculum. And there are kind of two streams of it. One goes with Newman and others into the Roman Catholic Church, and has enriched that with some things that were in danger of being forgotten in the 19th century, including the place of religion in the public sphere. And the other stream stayed within the Church of England, and Pusey House is part of that stream that stayed within the Church of England. These were his books, many of them that were bought when the house was founded, and his death mask is there behind Father George if you're interested in inspecting that. For our French friends here, one of Napoleon's death masks is at the Maison Française here, and it's very not well guarded. So if tonight you want to have an adventure and see if we can't get this and sell it to an oligarch or something, we need to do a roof on the chapel, and you might need something for the review. Yes. So it's just. But if you go to the Maison Française and say, "Show me his death mask," they just might do it. Now he was professor, Dr. Pusey, in Christ Church of Hebrew for 50 years. 50 years. That's a long. Nowadays, no one's professor for 50 years. Yeah, it's quite a proper long time. And this house is kept in his memory, and to keep that deposit alive and to be a witness to the university of continuing life of faith and its engagement with scholarship. So that having been said, we will turn this over to Professor Henri Torrione, who's with us from Fribourg. And you've given an introduction already of yourself, but is there anything else you'd like to say to the assembled before going into the question of is jus naturalis the same thing as lex naturalis?
Okay.
No?
Exactly. So I managed to change.
Oh yeah, like no, it's a PDF you sent, so I think actually you would just go there. So if you just
Okay.
and you can do it with your finger as well. If you just do.
Okay.
Yeah.
Good. Thank you. So thank you very much for the invitation. It's a privilege to be here, and I was very pleased during the pause to speak with the previous speaker here, who knows very well John Finnis, and I am such an admirer of John Finnis, in spite of the fact that I will criticize a bit John Finnis afterwards, that such an admirer that I was very impressed that he's still coming to the university, still working, and still have contact with some of you. I start with the subject matter is a fundamental disagreement between two natural law philosophers. John Finnis on one side, and the other one is Barden and Murphy, Law and Justice in Community. They have a fundamental disagreement. The disagreement is related to a position taken by a French philosopher, Villey, but it doesn't matter so much. It's really a disagreement between two English philosophers. And as Switzerland is a neutral country, I will allow me to step into the middle of this disagreement and to take position. Before I go forward with my presentation, there is a fundamental element which you should keep in mind when discussing natural law. It's the following. Natural law is an area where reason, Aquinas speaks even of natural reason, speaks an important role. You mentioned before, quite correctly, that there is a tendency today to think that justice and law is a question of will. And you mentioned correctly, it's also a question of reason. And I want to underline in this respect what Bentham has said. Bentham has characterized the philosophy of law and justice of Aristotle, saying Aristotle has developed all his philosophy of law based on a logic of the understanding. It's exact expression of Bentham. I want to do, Bentham is saying, something different. I want to develop my conception of law and justice according to a logic of will. And quite clearly, Bentham is the winner in our present world. But I know that this is wrong, that you can build a logic, build law and justice of a logic on the basis of a logic of will. How do I know this? Because I have spent 25 years of my life of discovering that it is wrong. My life, until 55, I am 70, until 55 was completely the life of a lawyer, involved in the practice. And in the practice, which is practice of financial law, of tax law, the practice which is maybe as far as possible with the position of the importance of reason in law. And I have discovered that when you are specialized in one area, and Joachim was explaining this here in Oxford, when you are facing difficult problems which are not dealt with by the rules established by the legislator, you have to have a different approach. And for this different approach, the activity of reason is at the center of the development and of the work of a law. I have experimented this case after case in the practice. And I have the impression that when lawyers say, oh no, everything depends on what the legislator has decided, they are not very much specialized in an area. They are on the surface of the things and they are not dealing with difficult problems. So this is a bit some introduction I wanted to make. I will speak here, therefore, under this idea that reason, understanding, is a centerpiece of law, of natural law also. And I start immediately with natural law as lex naturalis. We will see after that natural law as use in the Latin sense, and we will see that it is something different. This is very difficult to explain in English because the same word is used in English. Law is used for a law of parliament, and law in English is used for contract law, corporation law, where law doesn't refer to the legislation only, but to the corpus of the practice of the rule, to what is just in this area. The same word is used in English. It's a bit difficult for this reason, but you should not, if you are English speaking, imagine that because in French, in Germany or in Italy, we have two different words, droit, loi, Gesetz in German, Recht, and the same in Italian, the same in Spanish, that the issue is clear. It's not the case. So I start with lex naturalis, and I start with lex naturalis according to Aristotle. He doesn't speak about lex naturalis clearly, Aristotle, in the Nicomachean Ethic. He's mentioning lex naturalis in a very sharp way, with a very sharp analysis in its rhetoric. And is referring to what Antigone in Sophocles evidently means when she declares that it is just, so forbidden, to bury Polynices, a brother. Duty to obey. You see, here we start with someone who claims that on the basis of natural law, she has no duty to obey to the order that Polynices should not be buried. Aristotle has the following analysis, and I think even if it is in the rhetorics, I think it's an excellent introduction to natural law as lex naturalis. Aristotle says the subject matter in Antigone Declaration is justice and injustice defined in reference to laws. The definition of justice and injustice in reference to laws could be done in two ways, says Aristotle. There are two kinds of laws, particular, the law of a particular country, and Aristotle was thinking to the order of the king, that Polynices should not be buried. And there is another sort of law, general law, nomon koinon, and by that I mean, say Aristotle, the law based upon nature, lex naturalis in Latin, nomon kata fusim. Aristotle mentions the following precept as being a precept of natural law. First of all, the Antigone nomimon, the precept of Antigone, the right, the law which demand that a dead man should be buried by his relative. The Alcimadas nomimon, Alcimadas is someone who has written on the Messenian, which is an area close to Sparta, and it's a population which was kept in slavery by Sparta for years and years. And Alcimadas say, no man should be a slave. God has given to all men his liberty. Incredible, it's this nomimon, this precept which has been taken up in the Virginia Constitution in 176 and retaken a few months later in the American Declaration of Independence and then everywhere. It's a nomimon, it's a precept of natural law. But pay attention, and here you have to destroy an idea that you might have about lex, loi, law, nomos, or also customs, usage, the idea that they are themselves the source of authority. The Kantian idea of something which is a rule should be a rule right from the beginning, should be an order, should be a product of the will right from the beginning, and there is no reason in it. You will see, and Finnis is developing this very well, that lex naturalis is a precept of reason, which is the reaction of reason, of human reason, in presence of a good. It's a kind of way to protect a good. So the reason of the precept is the underlying good, liberty, or with respect to Antigone's relationship with the person you are living with, also after their death. This is the idea to bury death man. And the third precept, the third nomimon, is the Empedocles nomimon, no killing. No killing, the protection of life. Empedocles was about the idea, protection of any kind of life, not only human life, but it doesn't matter here. There is the idea that it is a Okay. Okay. If you think at this stage about the relationship between natural law in the sense of lex naturalis and natural rights, Finnis insists that rights derived, natural rights or human rights derive from natural law. Or you could formulate the things in this way: natural rights are formulated, expressed in natural law. There is a connection clearly between the two. But now we are going to examine another thing, another sense of the word law, which is not lex and which is not right. It's not. You will see that jus naturale cannot be translated by natural rights. At least it is the argument I will make. Finnis thinks it can be translated. The Dominican, in the translation of Aquinas, translate use by right in English. It's not correct. It's not correct. But this is the subject of my presentation, and you may disagree, and a lot of persons disagree because Finnis also disagree. So, Barden-Murphy say the 20th century French jurisprudence, Michel Villey, is right when he insists on the critical importance of distinguishing today between use and lex, as in Roman law, and between naturale use, natural law, and lex naturalis, natural law. So it's a distinction between two meanings of the word, of the expression, natural law. Barden-Murphy explanation about what is use. It is a just intrinsic to the situation under consideration. If I have time, I will study with you a case of self-defense. And you know that in case of self-defense, reasonable force could be exercised to set aside the attack, or to push outside an intruder. Reasonable force. Reasonable force, what is reasonable force? It depends on the situation. It's something which is intrinsic to the situation. It's something which depends on the circumstances of the case. So this is use. The problem, of course, as I told you, is that there is no easy translation of use in English. It cannot be generally translated by right. This I quote Barden, I think he is right. In very many places, in English translation of the Institutes of Gaius and Justinian, the term law is a translation of use, not of lex, and in spite of the fact that sometimes in Latin use could be designated, could designate also what we would call the right, it's only in very seldom cases. Of course, the Latin and the Greek didn't have the concept of right. Aquinas, now you have to pay attention because here there is a possibility of confusion. There are laws, leges, which are essentially the expression of what is held to be intrinsically or naturally just in a given situation. So there are leges, laws, which are not similar and which would not be called by Aristoteles nomimum, which are different. It is necessary, therefore, to distinguish between lex naturalis, universal precept, such as the Alcimadas nomimum, no man is slave, everyone is free, according to nature, and laws which are essentially the expression of what is held to be just in a given situation. Just in a given situation, for instance, a post-marital maintenance has been decided by the judge in case of a divorce, and the rule that the duty to pay maintenance expires on the remarriage of the party entitled to receive maintenance. I don't know whether this is a rule in England, I have not checked. This is a rule in Switzerland, it's Article 130 of the Swiss Civil Code. And you see, in this case, it's an act of the legislator. It's not an act of will, essentially. Essentially, it's an act of reason. You just have to look about the discussion. Should it be interrupted in case of remarriage of the party which benefit entitled to receive the maintenance, or should be not? Should it be interrupted even if the paying party is a rich man or a rich spouse? And the legislator has decided, it's fair, correct, to decide that it should be interrupted. It could have said, the legislature, it should be in principle interrupted. In such a case, it would make reference to the intelligence of the judge, which could be decided based on the circumstances. In this case, it has decided interruption of payment, except if there is another clause, a specific clause for the continuation provided in the marriage contract. All this is a work of intelligence. But the work of intelligence which is not related to a good, as in the case of lex naturalis, a work of intelligence which is related to specific situation, to specific case, with category of case, which is dealt with by the legislator in such a case, in such a provision. There is an analysis of Aquinas in this respect. With respect to this type of laws, Aquinas say these laws, as this article, as you mentioned in the Swiss Civil Code, are not the same as use. They are not the same as what is just in the situation. They are the expression, the formulation, the normative formulation of what is just, which takes place quite often after several cases, sometimes. Normative expression, they are, Aquinas is saying, aliqualis ratio iuris. You discover, if you understand this language of Aquinas, that law in the sense of what is just in the situation of use is not a normative phenomenon in such. It's only when it is formulated that it becomes normative. But nomima, what Aristotle called nomima, for instance, the nominum of Antigone or the nominum of Alcibiades, are right from the beginning normative. Right from the beginning, assuming the understanding of the good which should be protected, and this understanding is of course underlying this type of nomos. Now I come to the position of Finnis. Another position on jus naturale, then the one I explained to you so far. A stricter derivation of jus naturale from lex naturalis than in Aquinas. I don't know whether Finnis would consider that this characterization is fair or not, but it is my impression that in Aquinas, jus naturale is not deducted, and there is not a clear derivation from lex naturalis. Whereas in the Finnis approach of Aquinas, there is such a derivation. Finnis say, unfortunately, Villey treatment of use is marred by an exaggerated distinction between use and lex. According to Finnis, when Aquinas refer to use as that which is just in a given situation, Finnis sees this as a reference to the ensemble of juridical relationships established by rules between two or more persons in relation to some subject matter. Here you have the problem in this statement of Finnis. Finnis thinks that what is just in a given situation, for instance, there is an intruder in my home, I react, I expel him, he has a problem, I have broken his arms, even I have killed him, maybe, and there is a judgment. Was this excessive force or not? At least at the end of the day, there is a judgment. This is not excessive force, I assume. You see, is this judgment in the case the result of the application of a rule? We have an ensemble relationship between the two parties, the intruder and the homeowner, who has expelled him. Is it based on rule? You could say it's based on a rule. It's a rule of the proportionate force, of the reasonable force. Is this a rule? I am saying it's a mockery to say that this is a rule. It's a useless rule. What's the usefulness of a rule which says the force should be proportionate to the circumstances if there is no definition of what is proportionate to the circumstances? I know plenty of this type of rule. In Switzerland, we say, what is equal treatment? Equal treatment is treating the same situation in the same way and the different situation in a different way. Thank you very much. So far, I could reach without the help of the law. And it's only then, when you deal with precise case, that the difficulty starts. So this is use according to the Roman law usage. When the difficulty starts and when you enter into the merit of a case which should be adjudicated, and in order to adjudicate the case, you have to go into an analysis of the case, and you have to find reason in one sense or the other, in the other sense, and argue and confront the position and find out what is the best. Anyway, this is the position of Finnis. Finnis is going so far as to understand the term ratio juris. I explained before to you how it's used. It's used by Aquinas to express, to indicate the expression of use. Ratio juris, according to Finnis, designates the reason or the ground of the use. He argues the law, lex, that is the ratio of the use which is the object of justice, is primarily lex naturalis. This cannot stand. This is not correct. Ratio juris is used by Aquinas. It's also used when Aquinas speaks of ratio antis. Ratio antis doesn't designate the ground or the reason of the being. Ratio antis designates the expression of the comprehension of the understanding we have of this reality, which is being in this case. And Finnis has the following objection against the claim made by Villey, when Villey says the law use is derived from the fact of the case. Finnis is reacting by saying, this is getting a note from an is. It's not acceptable. As time is moving forward, I will immediately give you the answer to this point. the reaction, which is not given by Barden, but for me, I am thinking to this problem for years and years, and I have the feeling that now I am able to give an answer. The answer is the following to Finnis' objection. It's not deriving an obligation or right from the fact. The obligation or the right are derived from an appreciation of the fact, from a value judgment on the fact of the situation. A value judgment whose object is what is proportionate, what is equal, what is adequate in terms of relationship in these circumstances. For instance, in terms of use of reasonable force to expel an intruder. So you see, value judgment on a relationship is not referring to a value. It's determining what is adequate. It's a value judgment. And from such a value judgment, you could then derive right and obligation. And this, in addition, it's said by Aristotle. I go directly to this one.
Here.
Yes. It's said here, what is done is not getting a note from a list, because the starting point for a note is a value judgment of what is justified in the circumstances. The adequacy of the force to the circumstances is the central point. As put by Aristotle, when the equal to ison has been grasped, understood, you determined in this self-defense case, this was adequate, this was okay, this wasn't okay. But you have to be in a situation having to make such a determination. It's a practical issue. Aristotle says when the equal has been grasped, then people say that they have their arm. Sum quique tribuere. To auto again to auto. So what is there? It's not new at the beginning. It depends on this value judgment about the relationship as a whole, taken as a whole. And from that, everyone will know what is the right. The right, for instance, to defend himself with a knife, in spite of the fact that I was attacked without any arm and without any knife, or not the right to defend myself with an arm. You see, the value judgment of the fact is an element central to use, to the work of the lawyer, who has to deal, in any case, it has to deal with situation and to find out what is adequate in the situation. In the situation, if it is a general situation, depending on the characteristic of the situation, if it is a case, a specific case, dependent on the particular circumstances of the case. And this is the work of a lawyer. Anytime he has to deal with a difficult case, he has to find an answer without applying existing rules, or the existing rules are useless, as I mentioned to you before. And he has to find an answer. And why this answer has some element of necessity? Because the element, the characteristic of the situation, or the circumstances of the case should be taken into consideration to find out what is adequate, what is justified. justice, in this sense, is what is justified. And Aquinas say about use, what is justified, at the end, it is some kind of equality. To ison, say Aristotle, equal. At the end, it should be, in all the case, between the person involved, more or less, with some relationship, with some ideas of an equality, which is clear in a self-defense case. But it's clear also in case you divide some kind of common good, or yes, some kind of common good. The idea of equality is not an idea for which you need a precept to apply, an obligation to apply. It's simply, this is said by Aristotle. Everyone is convinced that in order for the decision not to be arbitrary, it should be equal. If it is not equal, you need a specific reason and you test the reason where it's worth or not. You see? But Aristotle is saying equal is simply arithmetic, and it's accepted as going without reference to any norm. This is the reason, and I finish with that in order not to. This is the reason Aristotle start his study of just law and justice in Book 5 of the Nicomachean Ethic by making a very important division. It's a division, Aristotle is saying, dikaion in Greek, just, could be understood in two ways, two different meanings. Law could be understood in two different meanings. You see that you, English speaking, have the same problem than Aristotle did with the term dikaion. There are two different meanings. One meaning is law as conforming to standard. Sometimes it's translated by lawful, but it creates misunderstanding. Law is conforming to the standard. This is the case of the precept, but conforming to a standard which has been formulated by natural reason. Aquinas has developed all this very well, and Finnis has explained this very well, defined by natural reason, a norm which has been defined by natural reason in order to protect the good. The good, the basic human good, which are the end of human life. It's not directly the common good, but the common good is not far from that, but we are at this stage not yet to a common good. Because Aquinas say if you're in a situation where you speak in common good, there is something already put into place by the human. And here at this level of natural law, we are not quite at this level. And the other meaning of dikaion, of law, is just qua-equal, taking no more than one shares. And I give you this example of self-defense to illustrate this. The result of all this is Villey is right by distinguishing these two senses of law. Murphy and Barden are fully right by supporting Villey, and Finnis is wrong. Finnis is trying to put into place a derivation from natural law, which is explaining very well natural law, but a derivation through proposition. And Barden say very well, it's not proposition. The derivation is not connected with proposition. Natural law in the sense of lex naturalis, the Alcimadas, Antigone, Nomima, they give just direction, just general orientation, but they cannot be reduced to a formulation which would be the basis of a derivation, including, if you imagine, intermediate principle. Finnis is wrong on this point because he's not following Aristoteles and Aquinas. Of course, Aristotle doesn't explain why he is making this division, but it's a strong division and it dominates all his treatise on justice and law. With respect to Aquinas, the distinction is made between the secunda prima secundae, where there is article question 94, article 2, which deal with natural law. Wonderful article, the most important of that, and Grisey and Finnis is fully right in this respect. And you have then secunda secundae, where is dealing with justice in the sense of the right solution to practical cases. And is not clearly making the connection between the two, except with the Decalogue. At the end of the Treaty of Justice and Law, which starts at Article 58, question 58, and it's question 122, 123, is dealing with the Decalogue, and he says Decalogue is principle of justice, and this principle of justice are conclusion compared to natural law. But conclusion, if I kill someone because he is attacking me, and the only solution for me is to kill him, I am doing something contrary to Decalogue. You see, Decalogue, it's not the only issue. It gives the direction, no killing. But then, this doesn't assume that I will accept to be killed. I have to defend myself. And here we come, what is reasonable force? And we come to the law. It's not the determination which is made, which is called determinatio by Aquinas, is not a deduction from natural law, but natural law is presupposed as giving a general orientation. But as Barden, and this is, I terminate, as Barden says, there is no derivation by way of proposition. Derivation by way of general orientation, in the sense of Dworkin, who was speaking of standard, yes, but derivation is not at this level something made by proposition, and there is a kind of jump which in another area where you have to decide cases, and here it's a determinatio which has to be made on the basis of the circumstances of each cases. And maybe just one additional point, Amartya Sen, the idea of justice, is right in this respect. He's not discussing natural law, but he's discussing the liberal position that the justice, absolute justice, is the realization of all human rights. Amartya Sen says, no, this is wrong, this is a bias. If there is a right, it never means that you have not to go through an examination of the situation and end up with an overall judgment of what is just use and what is not just. Other author, contested by Sen, say, if there is a right, this is absolute, and there is no examination to be made. You see, it's well, sorry.
Thank you very much. Yes, and
You're a bit exceeded my time.
and so I'll introduce myself because there is no need for introducing the speaker. I'm Philippe Stoffel-Munck. I'm a law professor at Sorbonne University in Paris, and I will try to chair the discussion after Prof Price's presentation, without any slides, obviously.
No slides, but I do have a handout. the very Oxford fashion. While I'm handing it out and hiding the tech, I will say something. We have lunch where we're going to treat you to England's great contribution to the culinary world, which I think is even a word in French. That is le sandwich. Yes. So we have a cold sandwich lunch, which means we have some flexibility with lunch, but that also means that we can do a little bit of a tour. So if you want to, we can show you the chapel, the library, and for those who are brave and have good insurance, we can take you up Pusey Tower, where we can show you all of the colleges of Oxford that could be yours, if only. Yes, if only. But most towers in Oxford aren't accessible anymore because of a use related to health and safety, I think would be the best way to explain it after your presentation. But we still have the keys to this. It's about 100 steps. It's about 100 steps up. Any more needed? It's about 100 steps up and 100 down, or one down, depending how you step. Does anyone not have the handout yet?
I don't.
And we can also show you. We have some beautiful bits of Gothic revival architecture here. We have one here. Oh, sorry. In Pusey, and believe it or not, this building is an early 20th century construction made in the Gothic style. So it's very Oxford movementy to find new skin for old wine. Now, some of you heard some of this before. I apologize. You know, some philosophers write many books. Some philosophers write one book many times. Some philosophers don't write books, but say the same thing whenever they're asked to speak, and that's me. So I am busy with a tome on the topic, but we'll see whether I actually find the time between my 4 kids, 1 wife, 3 or so countries, and 1.5 jobs to get this done. Now, I'll give you a little abstract of where I'm going with this, and it goes like this. You know who Adam Smith is, right? We all know Adam Smith. By the time Adam Smith declares, quote, the obvious and simple system of natural liberty and the inviolable right to property, which I've quoted in full, that quote in your handout. I should have started a timer. If I go over, then you don't get to interrogate us. Which you might want to do, especially you, Clemente, because there's a few coming right back at you after this morning's sneak attack. Now, by the time he declared the simple system of natural liberty and the inviolable sacred right of property, we're about 150 years into the reception of Grotius's mature thought. In 1776, Smith inherited, by way of both the Scottish Enlightenment, including Lord Stair's Institutions of the Laws of Scotland, and the writings of Hobbes, Locke, Pufendorf, and others. He inherited Grotius through 2 streams. One was his own upbringing in Scotland and the laws that had been written in a Grotian fashion, which I'll get to a little later, and the other was this tradition of political philosophy and newer natural law thinking on the topic. Now, what does such a system consist in? That's one of the questions here, and I think I'll get to it. By the end of this short lecture, I'm going to talk about the way it manifested itself in law, the way it manifested itself as a system, and the way it manifested itself as a school. That is a school of law, a system of law, and law with a big uppercase L, that is natural liberty, or an obvious and simple system of natural liberty. Well, in his De Jure Praedae, Grotius presents natural liberty as the power of the individual to act in accordance with his own will. Moreover, liberty in regard to action is equivalent to ownership or dominium in regard to property. The reason he gives for this is threefold, or they are 3 reasons: that God created man liber, sui juris, and aut exousion. I'll detail those 3 terms briefly later to tell you what he means by how God created us. It should also be noted that Grotius has a relatively low view of the effects of sin on us after the fall. He's a Christian, he believes in it, but he's in Holland, and he's pushing against the Jansenists and the Calvinists who are arguing that we are so affected by sin that we could only do well or do good, as was detailed in Professor Neuville's talk earlier, only do well or do good by an act of grace. He's pushing strongly against that. We were created with this ability. We fell. We've made mistakes. We've erred. But we have the power, also through grace, but also in our nature, not to sin and to choose the good and do the good. So he has a relatively low view of sin. I think in his defense of Christianity, which was a bestseller, international bestseller in his own lifetime, it was the thing he was best known for. Sin comes up 3 times in a book that defends the truth of Christianity, and that's relatively few if you've ever read books defending Christianity as a whole, you know. So relatively low view of sin, which allows him to say man was created liber sui juris aut exousion, and still remains largely those three things. Now, De Jure Prati wasn't published during his lifetime; it was circulated. It was written early. It was written around the time that he was under the influence of Arminius, the radical free will theologian of the Netherlands, 1608, 1609, widely circulated but not published in his lifetime. We don't know why. The only part that was published was the chapter on the free seas. So that's the one bit that made it out as its own bit of as a tome. The rest wasn't. But, of course, in De Jure Belli ad Pacis, Grotius explains the doctrine of natural liberty to imply natural promissory powers, of which we've heard earlier, natural promissory powers of persons, and the term that's used here is a continuation of the Roman law and theological concept of persona. So these are natural promissory powers of persons, God-given. When he says natural, God-given is implied. And these powers are the means by which rights are conferred from one person onto another. Promises are, for Grotius, first formalized as contract that is given legal form in a state of nature, but they are able to become the basis of municipal law if and only if practiced honestly, with the whole sense of what honestus would mean in the Latin, amongst beings with a desire for society with others. That's the second thing that came up earlier. Grotius does not follow the Aristotelian tradition or many of the ancient traditions that are either agnostic or negative about whether humans have a desire for society with others. Right? He actively teaches we like one another, we want to be around one another, we're curious about one another, we're going to mingle, it's a good, we understand it to be a good, and we seek it out and we like it. So he doesn't need to say why we would build cities, because we want to thrive or something like that. Why would we exit our families and build cities? The Aristotelian justification is largely, it allows us to do things that, unless we're a god, we wouldn't be able to do otherwise, which is, if you don't want to do those things, or you don't need the city, then there's no need to actually live in a polis. Grotius is, with some of the Stoa and others saying, some of the Stoics and others saying, we actively enjoy one another and seek one another out. Come and sit anywhere you like. Don't worry, please. Now, Grotius' system of natural liberty was formalized by him only in part as municipal law in his Inleidingen, or Introduction to the Jurisprudence of Holland. To a certain degree, he played a role in Holland that Lord Stair would play in Scotland and that Blackstone would play in England, giving formal treatment, and that actually Justinian played for the later Eastern Roman Empire, giving a definitive treatment of the law, which is for students, for those who are studying the law, and also is itself considered by some to be either a source of law or to have legal effect. So Grotius did that for the Netherlands. That's the one place where we see his doctrines actually applied to the customary and Germanic, ultimately, law that had an intermixture of Roman law principles, with it, because half of the Netherlands had been parts of the Roman Empire and half actually hadn't. Right? So north of Leiden, like Amsterdam and places like that, weren't actually Groningen and that bit. So it was this admixture. So we had to actually think about Germanic principles in light of a Roman law inheritance that was inflected heavily by his belief that what he's dealing with ultimately is an individual created free by God, situated in a world amongst people that he wants to be in relations with, and he has the capacity to be in relations with it if only he practices the virtues of promise keeping and doesn't betray a certain number of things. If God says it in the Bible, don't do that, you can't contract that, you can't do it. You also aren't meant to rape, poison wells, betray confidences in order to win a war, and there's one other, like never do, right? But other than that, the way you make your way in the world licitly and in good faith is by finding others, forming relations with them, making promises, and keeping them. Now, this is not his justification for the origin of the state. This isn't, he doesn't actually have an, he thinks humans have always found themselves in a position that this is how they operate. So the state of nature isn't something out there where you have, native tribes or uncontacted people or something, and then suddenly they find themselves in cities. The natural promissory powers are always there and are part of the ways they relate to one another if they don't have blood relations or nearness of kin that could substitute to a certain degree for that. But even when there is nearness of kin and blood relations, in order to conduct business or in order to engage in any type of complex relation with others, you need to start promising things and then doing what you say you're going to do. And these will need to have some sort of, eventually, enforcement as they become more sophisticated or more important, or if they're promises surrounding the defense of a fortress, if they're promises surrounding being watchful, staying awake while at the shoreline for the enemy who's coming. Obviously there's promises in promise keeping that involve life and death. But beyond that, there's promises and promise keeping that involve commerce and making your way in the world, dealing with people who are outside of your community. And so the enforcement of those has a sort of natural effect that the more promises there are to be kept and the more people that are involved, the more likely we're going to need to regulate it or come up with a way to organize ourselves together. And so Grotius's account is more like an outworking of what it means to be a creature that's busy with promises. So when Adam Smith talks about the system, do you need to excuse yourself for a second? It's all right.
Allergy.
It's my ideas. Sometimes it happens, It's me too. I have to just get rid of them,
More positive.
No. It's very good. We would have cut you off sooner if they weren't that good. That was the way. Now, I've spoken a bit about. The simplicity. The simple system is both simple in its parts and simple in the way it works itself out. It becomes complex without being complicated, because it's made of these individuals that have an interest and a desire to form certain kinds of relations with one another, and there's a belief in the universal brotherhood and of one monotheistic creator of all peoples. So it's a pretty handy package to bring along, let's say, if you're in the East India Company, and he was in the employ of some of these heads of state and others, to say, well, how are we going to interact with people that we might only be able to share very basic signs with? We don't share one God with them. They might have many gods or none at all. We don't have a tradition of, as you rightly pointed out, understanding the meanings of the terms in our very simplest moral reasoning. To render unto another what's due to him is very good, as long as we have a sense of what might be due to another. If we have a sense of universal equality, it might be easier to render unto others what's due to them. If we're ensconced in a very hierarchical society, rendering unto others what's due to them is highly contextualized, and it would take the person who's enmeshed in that society to know how it should be rendered. So what do you do when you come across, like, the Portuguese on the sea and they say, we own all of it? And then you come across, right, or the Spanish say, we own the moon and we own all of this. And then you come across the English as the Dutch, and they say, well, sometimes we're friendly, sometimes we're not. That's relatively easy. There's still like Christian populations, you have some, but then you go even further and you come across natives in the New World. You go even further the other way and you come across civilizations that are very different from your own, Chinese and otherwise, and Indonesia, India and other places where there isn't an obvious law or manner or way to relate. And so sometimes these questions look to us like imaginary, the thinking of this state of nature that's out there, that doesn't really exist. But for them, the state of nature was often the high seas, the wilderness, these new places, these yet to be contacted people where they had to ask themselves, how do we go from here to a form of relations which is beneficial to us and hopefully also to them in order to accomplish what we're out here for: adventure, gold, land, liberty, that is the ability to worship or to pray in the way one wants it or the way one believes one is obligated to. And Grotius is that the genius of what Grotius provides is he provides not only a justification for the law that we see in front of us, why it should be obligatory ultimately if we started to tear things apart and tore it down to its very basic skeletal frame. Why would we still affirm it? That's why Rousseau hates him, right? Rousseau starts out, Hobbes and Grotius are the two people that get named immediately because he thinks Grotius ends up justifying the old order in new terms, but terms that make it seem justifiable to people, getting a right from nature, deriving a right from nature, deriving a right from something that is a fact of nature, right? Getting an ought from an is Rousseau's open criticism of Grotius, which isn't what he does, I argue, because what he's getting an ought from is ultimately from divine creation of humans. That's where the ought comes from. But the system is simple, and by the time Adam Smith received it, he was able to look back and see this. But what I want to suggest in about 10 minutes or less is that Grotius is right to see liberty at the heart of what the project of the Western legal and moral order has been busy with. And for there I want to actually turn us to some of the ancients in our tradition, that place where Christianity and the Roman law first come together and start to heavily influence one another, and that's with Justinian. So I've provided you some extended translations from Mere's translation. It's a late 19th century translation, which I've slightly tweaked or updated here or there, not to make my point, but because some of the words that he used aren't the words we would use anymore for that. But it's the same text that's used as the first course Roman law text for the students at Oxford. The undergrads also use this when they're introduced to private law. And I want to point out something that might surprise us, because we're used to thinking of liberty as modern. I mean, Benjamin Constant was mentioned earlier in his distinction between ancient liberty and modern liberty, but we're used to thinking of liberty of individual persons as modern, and Constant also would talk about it in that way. But if you look at Book 1 of Persons, we don't first begin with liberty, but we'll get there very quickly. We begin with principles that look like they're derived from Aristotle or from an ancient book of ethics. Constant and perpetual wish to render everyone his due. That's justice, is given the definition. Jurisprudence is knowledge of things divine and human. Science of the just and the unjust. Then maxims are given, or the really principles are given. To live honestly, to hurt no one, and to give everyone his due. Skipping down, there's curious things about the law of nature which actually chime with your talk, and that is, he suggests the law of nature amongst the animals that causes them to reproduce is an instance that we observe, and then we have our equivalent, which is marriage. So reproduction between male and female, that division that belongs to the animals, we see it, and we have the term matrimony applied to this for the bringing forth of children. And so there is this way of approaching the law of nature, which also becomes, by the study of it, a law for us, a natural law for us on how we might behave toward human reproduction between the sexes. What's then given is a distinction between the civil law, which is the law of a particular people, and the law of nations, which is a collection of the law of all the nations' laws, if you had kind of an average of what they were like, the wisdom of all the nations collected over time. What we get immediately after this is a description of some of the things that the law of nations has amalgamated. And what we see here is wars arose, this is at the bottom of page 1, wars arose, and from their train followed captivity, and then slavery, which is contrary to the law of nature. For by that law all men are originally born free. Okay. That's something you probably didn't know was here, unless you've read this text before, right? Probably you look at the Constitution of Haiti, or some French documents, or even some American revolutionary documents to think you'd find the origin of something like that. By nature, all men are born free. What does this mean? On the next page, we have interesting things about, the establishment of ancient custom, which are law or law-like, is sanctioned by the consent of those who adopt them. So there's also this language that bleeds in that there's some relation between these persons, natural birth, and a consensual relation to the laws that are over them. Now, it's not a consensualist construal of the law, it's not a contractarian construal of the law, but the language starts to bleed in here in a way that it hasn't earlier in. And remember, what we're reading is not only a description of the law, this is the law itself of Justinian's Institutes. It's a handbook to teach lawyers, and it has the force of law. Now, the laws of nature, says here, which all nations observe alike, are established by divine providence. They remain ever fixed and immutable. Now, great. Slavery is against human nature. It's forever. It's according to the law of nature. It's forever fixed and immutable. So we're going to go forth now and just have universal emancipation, right? And we're going to fast forward to the modern world. Well, not quite, because then the law of persons comes in, and the law of persons, at least a third of it, is about the regulation of slaves, right? So the curious thing about this law, the first curious thing is, there's a clear statement of the great economic practice of ancient empire being against the law of nature and man being born free. And that this is divine and immutable, fixed, etc. And then a municipal law that goes forward and just doubles down on all of the patterns of slaveholding that the Romans have gotten used to in the whole history of their empire and before that of the city. So you have the law of nature, or the natural law, that is there and known, but there is no necessary connection to that and what is permissible in the civil law. That is, convention can curb, and does curb in this law, explicit statements of what is for or against. It would be like the matrimony bit if they had declared, we learned this from animals, we have matrimony, and now we have, 50 different ways to marry whomever you want or whatever you want. It's that type of logic that's present here, and it's peculiar. And I call it Justinian's bad conscience. Justinian's bad conscience. Now, how do we know it might be a bad conscience? That's the next bit. There's a formal bias toward manumission and freedom that's then present in the law of slavery. And I've given one example here, which is this extended quote, Roman numeral 4, the freeborn, which says the person is ingenuus, who is free from the moment of birth by being born in matrimony, parents who are born free, made free, etc. But then it says curious things like this. And when the mother is free and the father is a slave, the child is nevertheless born free, just as if his mother is free, and it is uncertain who is his father, for he has no legal father. And it is sufficient if the mother is free at the time of birth, although a slave when she conceived. And on the other hand, if she be free when she conceives, and is a slave when she gives birth to her child, yet the child is held to be born free. For the misfortune of the mother ought not to prejudice her, her unborn infant. And then here's the really interesting one, the most interesting one. The question hence arose, if a female slave with child is made free, but again becomes a slave before the child is born, whether the child is born free or slave. Marsilius thinks it is born free, for it is sufficient for the unborn child if the mother has been free, although only in the intermediate time, and this is true. So if at any point during gestation, the mother is freed, so she's slave at time of conception, freed, and then re-enslaved, the child is then born free. So this is an initial way, and then the next things are slaves can be manumitted anywhere at any time, if you look at that, and down freedmen, whether the praetor or others are passing along, right? It's fascinating. So Justinian declares certain things to be law, which are completely curbed, ignored, and denied within the private law that follows, within the civil law that follows. But builds in a formal bias toward manumission. There's a long-standing argument, why did slavery go out of practice and fashion in the Middle Ages. I haven't written an article on this, but someone should, who's a Romanist, not just someone who plays at being a Romanist, by which I mean a student of Roman law in this university. So a real Romanist should write an article that says, maybe it was because the Roman law texts that were passed into the Middle Ages at the full dissolution of the empire included this Christian principle of natural free birth, and had a formal bias in favor of manumission built in. I think that could be a plausible account of why this happened in Europe. No one's really, to my knowledge, provided a good history of the complete removal of slavery from Europe from the time of at least the High Middle Ages. Now, I'm sensitive that I don't have a lot of time left, and I have lots of pages here that I haven't read. What I want to do is turn your attention toward those three concepts that Grotius gives us. I've given you, Arminius was a student of Grynaeus in Basel. And Grynaeus was a high Calvinist, and he believed in Luther's terms, not Calvin's, in the bondage of the will. And he very much taught a circumscribed liberty. And I've given a quote of his from one of the Disputatio Theologica that he might have had Arminius argue when Arminius was a student in Basel. It says, I propose for the praise of God and for our edification to demonstrate that God is aut exousion, and the most freely acting being, and that man, on the other hand, is hup exousion, such that his freedom is circumscribed in its center and extent by obviously, the laws of God. God is aut exousion. What might that mean? We'll get to that. We are hup exousion. Arminius, I haven't quoted you here, says mankind is aut exousion. And Grotius picks this up from Arminius's treatment. So the direct line is Basel, Arminius, Grotius, a direct line. The reason this word seems to show up in Basel is because Theodorus was published a couple years earlier, and this was used as a Greek equivalent of sui juris in those texts in Basel. So that's probably the proximate origin, but it became a theological term in Calvinist circles. It's used, exousios and other words like that are used in the scriptures. This is meant to be treated by Grotius, so it seems, as one's own authority in matters that aren't obviously delegated to someone else. One's own authority. So if it's not forbidden, if it's not enjoined that you must do it, then you're the one who decides whether it's fitting. You know, you have Aristotelian vices, two opposing vices, and that whole space in between that can be virtue. Well, you're the authority. You're the authority that decides how close to cowardice or how close to foolhardiness you might go, rather than someone above you or some mastermind of the moral world who gets to tell you what the fittingness is. Sui juris is a word you probably all are familiar with, and this is more of the legal term, right? So when you're sui juris, you're a full person before the law. You can own, but can't own. You have patrimony, and in the sense of the Roman law, you're a full person. You can own, you can't be owned. You can have your day in court. You can be sued in court. You're held fully responsible for your actions. And this seems to be actually about that. No law can be put over you outside of what God commands or what is reasonable. And to demonstrate that, I gave you a quote from Grotius where he says this is the bottom of page 3, right? For it is not the case if something is useful for someone, I'm immediately permitted to impose it on him by force, for instance, because for those who have the use of reason, the choice of what is useful or beneficial or not must be free, unless some right of somebody else has been established over them. So if it's not wicked, if it's not against God's divine law, if I haven't agreed or a right hasn't been established over me as part of a community or something like that, then I am sui juris. Then the last one is just the word for a free man, right? Liber is used. And then the full quote, if you didn't actually read it out, is quite striking because he's quoting Justinian. This is God created man aut exousion free and sui juris, so that the actions of each individual and the use of his possessions were made subject not to another's will, but to his own. Moreover, this view is sanctioned by the common consent of all nations. For what is that well-known concept, natural liberty, other than the power of the individual to act in accordance with his own will? And liberty in regard to actions is equivalent to ownership in regard to property. Hence the saying, every man is the governor and arbiter of the affairs relative to his property, which is a quote from Justinian on mandates. Grotius is arguing in this extended piece, which Aristotle and Plato brought to bear, which other authorities brought to bear, that you have a form of dominium over yourself or your will. It's precisely what happens when you promise someone is you limit your rights, or you maybe even give a usufruct to someone else. You say, tomorrow my time will be in part yours. It's perspective. And just like I might say, you may use the fruit from my tree for the coming year. When it flowers, I'll give you a usufruct over it. So the analogy here is to one of a right of ownership. We're not talking about self-sovereignty or something that John Stuart Mill or later would flower as liberalism. We're talking about what it might mean to be a human person, in this case as dominus, right? He thinks the full Roman citizen, the person with patrimony, who has power over his own destiny, is the model of Christian liberty that should be presented because it's based on the truth of natural free birth that makes us autoxusion sui juris and free, unless or until interrupted by God's law, revealed in the Bible or revealed in nature, or agreements made on our behalf or by us about how we'll make our way in the world. This is what Adam Smith saw as the heart of this simple system of natural liberty that was able to multiply itself in so many areas of human endeavor. And this is one of the reasons it could do this is, if Grotius is correct, because it identifies a very simple truth that is another way to get at a substantive natural law that is not itself a substantive natural law doctrine. It's a very basic, simple, observable truth about humans that has one theological proposition, that God created us this way. If that cord is cut, then I think what Clemente said this morning is true. It cannot stand on its own if that cord is cut. And so Grotians have frequently not been able to defend their own position, whereas I think Grotius would have been able to defend his whole position. The first time Grotius's principles become law is in the Law of Scotland. Lord Stair starts the institutions of the laws of Scotland with the first article, which is on freedom, where Grotius is quoted. And I gave a little bit of that here. If you want to know more about it, it's a fascinating history of the way Leiden, the Calvinists, radical free will thinkers, many Jesuits, like Lessius and others, all conspired with one another without knowing it to give Scotland its law that it has today, right? And you are now, you're not Scots, but you're in Scotland. You benefit from some of the glories of Scottish law up there. But basically, it's only had about a 10% atrophy since it was put in place in the late 17th century. So it's been remarkably resilient. And that might be because it's based on truths about human nature, the way some other legal systems, I don't mean this one here, but some other legal systems just aren't, and they fade away, they disappear. Communism is the most famous in the last century, and the fascist systems, which are not based on truths about human nature and don't have liberty at the heart of law. Thank you.
So I'm supposed to organize a 30 minutes discussion in less than 7 minutes.
No, I think we can go to 10 past or so we can probably have, well, let's have 20 minutes of discussion, and then lunch will wait, it's cold.
Okay.
Yeah, and if you need to leave earlier or you're hungry, then.
The question is always, the difficulty is always the first question, so I may take the lead on that. Asking you've mentioned the Grotius, and I quote, for what is that well-known concept of natural liberty, other than the power of the individual to act in accordance with his own will. But that lets me think of the modern conception of liberty as being a complete autonomy of the individual. And I wonder, Grotius said that in a certain context, in a certain time, where Christian education was such that some usages of liberty would not have come to the mind of an individual. And so, in a non-Christian society, or even in a non-religious Christianity or else,
Post-Christian society.
you know, a post-Christian society, but also a non-religious at all, non-Muslim either, non-Buddhist either. This definition, it seems to me, cannot work, because liberty is always predicated on a certain conception of good and evil. And what gives you this distinction between good and evil, the orientation you mentioned, is your education. So, in the postmodern or in the post-Christian society, what is the worth of that definition?
So it seems to me this definition is the foundation ultimately of his contract doctrine. That contract doctrine is now the formal way of justifying why contracts should be obligatory in private law of probably 90% of the world. So one real use in societies that are non-Christian or polytheistic or has been a way to allow people to engage in mutually beneficial relations with one another without having to have many other forms of agreement. Now, they haven't started societies this way. International law, which is based on some of these principles, is famously bad at having law, right? It's a conflict of laws and harmonization of laws often. So that one use is just in private law and contracts, and everywhere from China to Russia to South America, North America now has Grotian contract doctrine as its formal justification for why contracts should bind. Grotius himself, you notice, does not offer a thin definition or a one-liner. He ensconces this within Christian theology. He uses a Greek term, two Roman terms, just before Aristotle and Plato are listed. And then he gives the Roman law of mandate as an example, which I then quoted, which has a very specific way of risk management, that if in one's own case one may take great risk, but for another one must exercise great duty and care because one does not know what the other might want to do with it or have the interest. And so I think what he's saying is, if you want this teaching, these other things come along with it. This is my distinction between Grotius and Grotians. Many Grotians have been happy to say, oh, that Roman law stuff, we don't need that. Oh, that Christian theology stuff, we don't need that. What we just need are promissory powers. And I think Clemente's criticism is correct. It just doesn't work if you only have promissory powers. But Grotius didn't only have promissory powers, he had it enmeshed. Benjamin Straumann is you might know him, but he's in Zurich. Benjamin Straumann, very good, relatively young scholar. He's written a book called Roman Law in the State of Nature. A recent book, Roman Law in the State of Nature, about Grotius believing he found something true in Roman law, because the Roman law had best represented natural law and had worked it out over 1,000 years of what natural law might look like. And Grotius was doubling down on this. Straumann argues that that's what Grotius was doing, and argues pretty convincingly. So I don't think Grotius wants us to have a simple definition or to have an easy way with it.
Okay. Yeah, and anyway, does this definition, you said, well, pacta sunt servanda can be derived from that approach.
Yeah.
But what about the acts that you take for yourself? If I want to mutilate myself, must the law let me do what I think fine for me? It's not a question of interaction with other people, so there is no trade or society that's at stake.
Yeah.
It's just liberty of doing what I want to myself. And of course, it would not be found just to allow anything that you can perpetrate against yourself.
Implicit in Grotius's argument, and made explicit when Pufendorf takes this up, is the duty to preserve one's own life because it's a gift from God. Grotius doesn't believe suicide is permissible in a state of nature or afterwards, although sacrifice is. on behalf of others, right, which is known to cause death. But that's a premise of promissory powers and the meaning of prospectivity, right? That if I'm going to promise Clemente that I'll pay him to make arguments in my favor next time he gives his talk, you know, and I'll pay him afterwards, and then I go kill myself. I have permission to exit the world, right? The whole premise is that we're here as long as our natural lives will allow, and that can be relied upon. So it's implicit. Pufendorf realizes this is a problem, and so he makes it explicit when he takes up Grotius's. So yeah, but it's an excellent question.
And I have a last question, and the fourth question is always the simplest. So, it's more a comment than a question. When you mentioned Villey, Finnis, and the discussion on what is jus naturale, and you said, well, in Villey's view, I don't need to say Villey's view. In Villey's view, you have to look at the facts. You cannot decide on the basis of rules that would apply in the abstract. You always have to make your determination on the basis of the facts and making a balance between all the arguments that are debated, that are argued. I understand that. And in my understanding of the common law is very closer to that doctrine than, for instance, French law. But as a practitioner, I must say that, and you were a practitioner too, I must say that there is always the predictability question that undermines this approach, this two case-by-case approach. So, how to find a solution between the need for predictability and the requirement that something can be said as being just only when the whole context is put before the judge?
It's not a theoretical problem.
No, it's
It's
not.
a practical problem in the sense that predictability, no matter the effort which is done by the legislator, no matter the intelligence of the legislator, fails in difficult cases. This is the experience of the lawyer. This is the experience which is referred to by Portalis, who say the law, and he was very much centered on the law cannot provide for everything, and a lot of elements are left to the opinion, to the discussion, and to the judgment. The Swiss legislator has put a specific article, Article 4 of the Swiss Code, Civil Code, which provide anytime the legislator use a non-determinate concept, such as no excessive penalty, such as just motive to terminate an agreement, such as proportionality, please, then the work, according to this article, the work of the judge is not to apply the article. It's not the work of interpret the article, but it's
Or interpret in the sense of a musician.
No, not even in the sense of a musician. If you want. But this is a bit too artistic. You have to really decide, to make a hard decision on the case without the help of anything exterior. You have, if your image of the musician, the general melody, of course, the constitutional purposes, the general principle of working. There is always an orientation, and there is always clear problem if you go against this orientation. But this element of the failure to guarantee predictability which would be the ideal, if it would be possible, is already documented by Aristotle in his commentary to the Solon, the constitution made by Solon. Aristotle says there is a lot of question about why some specific legislation made by Solon with respect to inheritance of women in specific situations are so obscure. Solon was a great legislator, and this is totally obscure, this provision. And there is an interpretation which Aristotle discussed. It's because Solon wanted to favor the power of the people. And the court at the time was the people. And if you kept the provision of the law obscure, this was more power for the judge, which was the people. And Aristotle said, no, this is wrong. Solon has been obscure because on this point he was aware that no precise solution could be found by a legislator in the abstract, no matter the intelligence of the legislator. And I could tell you a story about what I know, try of the Swiss legislator to simplify a problem and total failure. This is not possible on certain points. And Aristotle said there is a resistance of the reality, practical reality, to abstraction, to human abstraction. Human mind is not God mind. And the abstraction is made by sacrificing the adequation or the quality of the solution. Therefore, I had a lot of agreement about this issue of predictability, and I always ask my students this question: predictability, secure of what will be the solution. Is it a principle of law, or is it just a policy principle? Is it a standard according to working language, or is it just a policy decision? It's a policy decision. There is no legal in it. It's a policy of the legislator. So I have not good answer except the answer which is reality.
Please. Thank you so much to both for the presentations. I have two questions, one for each. So Professor Henri, my question for you is, do you think Aquinas's and Finnis's treatment of the idea of determinatio could somehow like qualify your critique basically, which is that this kind of strict derivation of the use, the res justa from universal principles is not always possible. I say this because it seems to me that like there is a lot of room, both in Aquinas and in Finnis, for acknowledging the fact that many times the specification of the res justa is going to be a choice within a range set by natural law, but within that range it's going to be to some extent arbitrary, and that's what they call determinatio. And that is a way of deriving from natural law, but it doesn't presuppose this kind of strict logical connection that you are criticizing. So I wonder if, that could kind of temper your critique of things. And to Jonathan, very briefly, would you, or Grotius, I assume it's the same, agree that with the proposition that God gave us promissory powers so that we could use them for the good?
Do you want to go first? Not necessarily. They would be used for good, but not necessarily for the good. The good, we're sneaking in, you know, like, we're sneaking in Platonic forms at this point.
Forget about that. I don't.
There's an intentionality that they should be used for our survival and our thriving, rather than for a destruction of others and harm. And if that's what you mean by the good, yes. But if it's like the common good or some sort of kind of implicit political track, or I don't think there's a teleological, for Grotius, teleological claim about why we have the promissory powers. He says where they came from and how they're useful. But because so much of what you can do with these powers is left up to you, it's hard to know in advance what we might mean by the good unless we articulate it in generalities like harvesting and commerce. And
I agree that part of that promissory powers entail that a lot is left up to you. My question is, like, for the rationale for we having these powers, and yeah, okay, but that is all.
Aquinas distinguish conclusion from natural law and determinatio. Conclusion, he gives the example of Decalogue. You will not kill, or not kill. What is it?
Thou shalt not kill.
Okay.
Don't kill.
Don't kill.
Yeah.
This, he views this as a conclusion starting from natural law. What is the content of natural law, from which end up with you should not kill? The text of this is article question 94, article 2 of the Prima Secundae. It's a principle, one of the precepts of natural law, according to Thomas, is you are not going to do harm to other person, not doing harm to other person intentionally. Not doing harm by attacking a fundamental good such as life, including suicide. Okay, this is not only, this is clearly excluding, natural law is clearly excluding act going frontally, internationally against the good. But apart from this, you have all the other issues which are dealt with, for instance, by Roman law, which if you read the digest, many situations of property, of self-defense and other issue. And here, I think determinatio is more than a space left open by the natural law. The natural law is so general that you cannot go against natural law clearly without being a criminal. But law is far from being just criminal law. All the rest, and for all the rest, determinatio is much more than just a small space left open.
John Finnis makes a nice point about this, to give him some kudos here. Yeah, John Finnis makes a nice point. There's this idea that if we were all devils, this is Immanuel Kant, right? If we were all devils and we had perfect law, then we could all get on. And John Finnis says, no, that imagines that law has too much to do with our intention. Even angels, if they were driving cars, would need law to coordinate their cars so that they didn't bump into one another, right? So just coordination problems are a lot of what law deals with, and regulation nowadays is, whether it's law or not, it's an open question, but deals with all of this adiaphora, this indifferent space that can go in many directions that has to be dealt with somehow.
And then you have adjudication, and adjudication between two conflicting parties. And here, it's Hart was saying it's the choice of the judge. It's an arbitrary decision of the judge in this case. I think it's wrong.
Yeah.
I think it's wrong. All the question behind this is the quality of human evaluation. When a judgment is a value judgment. Value, I mean not the application of a value, but try to get a solution in a case which take as far as possible into consideration of the element of the case and the various possible solutions, and try to show that the decision is the best solution for objective reason, assuming that all the reasons pro and contra each solution has been brought forward and has been assessed. So it's rationality up to the end.
Perhaps one last question, yeah?
Great, thanks. So just quickly to both. First to Professor Torrione. How would you recommend we translate Jus nowadays? It may not be in all cases because some we may maintain the existing. But I'm thinking particularly of so the title of Finnis's major work, Natural Law and Natural Rights. It's been a struggle, I would say, for the natural law community to maintain a notion of natural rights. And the discourse on rights is very much taken by different camps who project a view of the malleability of human nature and future scenarios of equality justifying the prescription of legal rights and responsibilities. So sometimes I think it would have been better or more complete for the account to call it natural law and natural reason. But then we also cede the ground of rights. And maybe that would also happen with a different translation, that maintaining notion of right within use could be a way of maintaining that. And then if it's okay, a question to Jonathan, which is, I'm not convinced that Grotius's notion of freedom within the state of nature is true to our nature. So I get that we are free, and in a sense, in a state of nature, sui juris. But then he said, so that the action of each individual and the use of his possessions were made subject not to another's will but to his own. And I think, maybe I'm on a limb here, but I would advance the natural law account as having obligation within the state of nature, for example, family obligation. And so property is navigated in line with that first principle, which may be in common, as is often the case for families, may be unowned because our family lives in a jungle and no one cares who owns what, or maybe with some way of transacting or navigating between households. So what particularly was brought to mind is the idea of like father-son relationships and the notion of laziness. So it seems, I feel it's always bad if you have a lazy son. No matter your culture or level of state of nature, because there is some obligation to make good use of your time and to develop yourself and place your effort. So I wouldn't say that this son, and we're all from someone, this son is acting with just his own will, choosing what his possession or property entails. There's an obligation prior to even any ownership.
Is good points. Let me just be really quick so we can get to lunch. What if Finnis had called his book Natural Right and Natural Reason? Because the law is sometimes the difficult one, and reasonableness and law are very closely connected, and then the right is still there. Maybe that's another way to have titled it and just avoid the word law. If you're sitting in Goa one day and all of a sudden the Portuguese come and say, you belong to us, Grotius's statement becomes really important, right? Or if you're in Peru and the Spanish come and say, okay, well, now you belong to us, right? Well, we are the Peninsulara, you are people. And so by what right do you push back and say, no, actually, I'm not subjected to another's will? Now the question is, who's the I? And I think this is a trick that we've not gotten round. Up until probably the early 19th century, when political philosophers were speaking about individuals, they're almost always speaking about male heads of household and no one else, really. So Thomas Hobbes doesn't believe there's a war of all against all. he believes that heads of house are at war with one another and families organize themselves on different principles. Grotius as well, the statement is probably better read actually as those persons who have a public persona, and that differs in society, and who are trading and dealing and making these decisions. How families and households are organized is quite different. But I think actually he's not talking about every individual in the world, at least in the first instance, but he's talking about really male heads of household, and in some societies, women who are property owners and who trade and deal and have a public face.
Yes, I still think it's a mistake, because if someone comes and says, and I'm the head of my household, and says like, I own you, and I say, I don't think it's great to say, no, I'm free, I'm independent. It's say, no, I'm owned by my children,
Right.
and I own them. That we have responsibility to each other that predates your claim.
Well, you probably would, but if one head of a household goes to another head of a household and says, "You're now mine," what's the claim?
They say, no, I'm responsible to my people. And that's already the indigenous claim anyway, that we are part of an ancestry that is here. I've said too much.
No, I'll leave it at that. I would say more, but we won't then ever have lunch and go up Pusey Tower. So let's stop it there.
Thank you very much.
Thanks.
on more details article written previously, on which will be included the number 3 of the Revue de Philosophie du Droit. You hear me? Okay.
Well, you're the third speaker. Yes. If
Okay.
you mute,
Okay.
if you mute
Doing.
yourself.
Okay. Yes. Okay.
Nathan is incredibly concise. So he's probably not going to use all of his allotted 30 minutes, but slightly.
I'll pare it back against it.
No, it's all right. We'll do all right. We can make up the time a little later, but I'll present the three persons at once who are speaking on this panel. That's Dr. Nathaniel Helms, who recently received his DPhil from this university, from Oriel College, and he does something called philosophy of action, right?
It's like
It's actually a practicum more than a theoretical treatment of what humans do when they're out in the world working together or against one another. He'll tell you more about that maybe. He's going to speak about the chosen and the voluntary, which is a defense of traditional accounts of moral and legal responsibility. And this might chime and interact with some of what you did earlier, Professor Neuville. So if you have questions for any of the speakers throughout the day, you can address them to those speakers, and we can pick up conversations we've already been having, or active points of contention about true and untrue things. Dr. Dominic Burbidge will follow, head director of the Canterbury Institute, an august institution that operates alongside the university and enriches its curriculum by bringing people over here who are selected for a certain kind of excellence in order to do scholarship with humility as the virtue that they will approach truth with. And he's going to speak to us about what would a political theory of natural law look like, which we've been asking and not sufficiently answering so far today. So thank you for that. And then we have Dr. Arnaud de Solminihac, who wasn't able to join us in person, but he will actually speak to us. He's at the Institut d'Histoire de Droit, Jean Gaudemet, Paris II Panthéon-Assas, which I butchered, but it's a wonderful place, and unfortunately he's there and not here with us, but he will speak to us about the liberty to dispose of one's body, an interpretation of the freedom of trade and industry at the end of the 18th century, which might touch on some of the questions we've had about slavery, suicide, and other uses of one's time and energy and things like that. So without further ado, I will turn this over to Dr. Helms to tell us about the chosen and the voluntary.
Thank you, Jonathan. Small correction, still Mr. Helms. I've got to submit my corrections. That'll take about a week.
Oh, you're a doctor to me.
One of my faults as a speaker is I get sort of excited about what I'm talking about, and I sometimes go over. A lot of us do. I don't choose to go over. I make no decision to go over time, but the effect going over is bad. So what I've done in this case is I've asked my father to give me a little wave when I'm 20 minutes in. So had I not done that, and I had gone over, we might wonder, would I have been culpable for doing so? Again, I made no decision to go over. If I had, thought about it, I wouldn't have done such a thing. But I know myself, and I took indirect action to make sure I don't. So I get my little external help. I get my little wave. Nathan, time to shut up, time to end. you might think that if I had had the thought, oh gosh, I have this problem, I really should do something, but I was too lazy to do so, then I would be guilty if I did go over. That is my position. That is the traditional volitionist position. Position is that if you've done something culpable, blameworthy, then that is because you chose something at some point in the past that led you to where you were. It doesn't have to be a direct choice. Frequently, these choices are direct. Frequently, we know we shouldn't do something and we just decide to do it anyway. It can be indirect, as in the case I just outlined. Or if you want a simpler one, think of drunk driving. So the drunk driver, when he hits the pedestrian, did not decide to do that. He made no choice to hit the pedestrian. He's not really in control. The choice he did make was to get drunk and get behind the wheel. So, does he have an excuse for hitting the pedestrian? Well, sort of. So, again, he didn't decide to, and we might say he's not directly responsible for hitting the pedestrian. He's still responsible for what he did, because he's responsible for what led to that action. He's responsible for his decision to get drunk and get behind the wheel. So that is something he's directly culpable for. It has this consequence, him hitting a pedestrian, say killing someone. And so he is culpable for that just indirectly. And you can still send him to prison, you can still blame him for what he did. Now, there's all kinds of issues with, say, moral luck. You know, is he any more culpable or less than someone who got lucky and just didn't hit anyone on the way home? Some people like me think they're about equally culpable, but that he's culpable for more things. But that's controversial. Essentially what you're doing if you're a volitionist like me is you engage in what's called a tracing strategy. So if you find guilt, you have to trace it back to the choice. And if you can't trace it back to the choice, or if when the choice was made, it was made so non-culpably, perhaps you were coerced, perhaps you didn't know what you were doing, and you weren't culpable for that ignorance, then you're off the hook. Opponents, frequently called attributionists, don't think this is right. They think, well, right, maybe you made no choice. Or maybe when you did make a choice, you were acting under some false beliefs. But those false beliefs and the character that led you to behave the way you did, again, maybe those weren't voluntarily chosen, but those are you. They reflect you. So it's still your fault. It's still say shame on you if you do something bad. My view, the volitionist view, is still a majority view, but it's on the back foot right now. And there's lots of new attacks being leveled at it. I'm going to look at one that is sort of based in legal reasoning, actually, from John Hyman, who was until recently a professor here at Oxford and was briefly my supervisor. He's a great philosopher. It's a great book, Action, Knowledge, Will. You should read it. But I think he's mistaken here. So, for Hyman, the area of philosophy that deals with moral responsibility ought to be fundamentally concerned with figuring out what is voluntary, which for him is slightly technical. It doesn't mean chosen. I think it's about what's chosen. He thinks it's about what in law is voluntary. The problem up until now in his mind has been over-attention to, e.g., intentional action, choice. Attending to the ways in which passive states can be voluntary reveal as much. But once we give up the chase for a positive account of voluntary based in knowledge or intention or in self-control or in, fundamentally, choice, we come to see for Hyman what the voluntary really is. And here's a way too long quote from Hyman. What is voluntariness? Roughly, a thing is done voluntarily if and only if it is not done out of ignorance or compulsion. This is not the same as saying that it is done knowingly or freely. Regarding knowledge, if a man drives the wrong way down a one-way street, and it transpires that although he believed the street was one way, he did not know that it was, he cannot be excused on the grounds that he did not do it voluntarily. What does ignorance have to do with compulsion? Why do we have a concept that yokes together these disparate ideas? Again, ignorance, compulsion. The answer, I suggest, is they are both normally exculpations. And that part's right. I suggest that that concept of voluntariness is formed by negation, in fact, by double negation, by including factors that exculpate, in other words, factors that exclude guilt. These factors that negate voluntariness are ignorance and compulsion, regardless of whether the thing whose voluntariness is in question is an act, an omission, an event, a relation, a condition, and so on. Aristotle states this explicitly with respect to action and emotion. But the idea that ignorance and compulsion are exculpations was already ancient in the classical age, and it does not seem to have originated in any single ethical tradition. Indeed, it is hard to see how the ideas of guilt and innocence, as opposed to the simple idea of causing harm, could exist without it. Hyman's view is clearly enough stated, but its distinctiveness is not very salient until he elaborates on the relationship between voluntariness and choice. This relationship is crucial for our purposes. Alston's view, that's the sort of standard orthodox view that I defend, put here colloquially, is that we lack direct moral responsibility over whatever we cannot choose or refuse to choose. Since we cannot do otherwise in those cases, we have an excuse if things go wrong. Now, Hyman readily admits that voluntariness is closely connected with choice in some way. Quote, "It is natural to think that a person does something voluntarily if and only if he chooses to do it, or at least if he could choose not to do it. But, an examination of duress, the legal concept of duress, presents a difficulty," says Hyman, for my orthodox view. Lord Widgery, a former Chief Justice, defines the English legal position on duress as follows. "It is clearly established that duress provides a defense in all offenses, including perjury, except possibly for treason or murder of a principal, if the will of the accused has been overborne by threats of death or serious personal injury, so that the commission of the alleged offense was no longer the voluntary act of the accused." So, one conception of duress, choice, and voluntariness, our conceptions of duress, choice, and voluntariness for Hyman start to come apart. One way of understanding the word choice, the presence of some kind of threat, undercuts voluntariness and therefore guilt, on one understanding. But of course, in another sense, choice is still sometimes present at the same time as duress. So I'll skip through the technical language here, but if you're under duress, in some cases, you still literally have a choice. So in extreme cases, say maybe a severe torture, it's potentially the case that you're just incapable of doing anything other than what you're being told to do. But in other cases, you're given some severe threat, some threat that, in Widgery's language, overbears your will. But of course, you still have a choice. You can just die. If I put a gun to your head and say, hey, you have to do a demeaning dance, well, in one sense, yes, you have to do a demeaning dance. What choice do you have? Well, in another sense, yeah, you could die. You could just not do the dance and get shot, right? So it looks like you've got to disambiguate this word choice between, literal presence of a choice and, say, acceptable choice. Okay. If you're like me and you're a volitionist, you think, well, what matters is the literal ability to make a choice. That's the grounding of moral responsibility. So this is, you can see now how Hyman's argument is getting off the ground. He says, well, look, you have a choice there, but, not much of one. Okay. As Hart and Honoré, the great legal thinkers, note, the person threatened is literally able to choose whether to act as instructed or suffer the threatened harm, so that a choice exists. This is perfectly consistent with recognizing that duress does not always leave some kind of choice intact. It might be that some kinds of duress do literally render agents unable to do otherwise, as in cases of torture. But bracketing those, we can define what Hyman calls the Nicomachean view, standard view, correct view, according to which X is voluntary if and only if it is chosen as follows. Nicomachean view is duress completely vitiates voluntariness only when it renders agents literally unable to choose. So think severe torture. Alternatively, we might stick with Lord Widgery, as Hyman has done. This, he thinks, is consistent with Aristotle's Eudemian ethics and is later echoed in Aquinas. So this is the Eudemian view. Duress can sometimes completely vitiate voluntariness, even when the agent in question is literally able to choose to do otherwise. So e.g. if an agent's threatened with serious bodily harm unless he hands over his wallet, say. Then if he hands over his wallet, he does not do so voluntarily. He cannot be held morally responsible for what he does. So Hyman's main argument is a form of reductio against the Nicomachean position. Any crime of force, extortion, unjust conscription, or the example he uses is rape, can serve to illustrate it. So here's a quotation from Hyman. It is clear that coercion and voluntariness are opposed, where the patient of an act is concerned, because whether an act is voluntary on the part of the patient depends on whether it is done with her consent, and a sufficiently grave threat vitiates consent. In some cases, it is a matter of judgment how grave the threat must be. But if a rapist threatens a woman with violence, and she makes a conscious decision to submit, as she may if the circumstances allow her to weigh the risks involved, the idea that she must therefore have consented to the act, because she literally made a choice, and submitted to it voluntarily is repugnant and absurd, regardless of whether she was literally able to choose whether to submit or risk being killed. The advantage of the Eudemian doctrine, his doctrine, is therefore made obvious. For the Nicomachean doctrine requires us to say that if she made a conscious decision to submit because she judged resistance to be too dangerous, then she did consent to the act, and she did submit voluntarily. So, if the Nicomachean theory were right, it would be a defense against the charge of rape, or extortion, or unjust conscription, that the victim was, quote, literally able to choose whether to act as instructed or suffer the threatened harm. He's of course right about this. This would be a terrible defense to say, well, you know, the victim, you know, did in some sense make a choice, so the whole thing was done voluntarily, so no rape. Okay, so to get clear on our terminology, an act is freely chosen if and only if, this is Hyman's terminology, if and only if it is chosen and one could refrain from choosing it. He thinks this is not as important as the voluntary. And then an act is voluntary if and only if it is not the result of ignorance or compulsion. And what matters is not free choice, like the Nicomacheans, like me think. What matters is voluntariness and the absence of ignorance or compulsion. Let me just skip ahead a little bit. So if he's right, we have a basis for rejecting the Nicomachean view, which is the view that free choice is insufficient for moral responsibility. However, we should consider Hyman's alternative, which shifts the explanatory burden, and we'll do that now. So, crimes of force and duress. Duress may stem from agential or non-agential threats. To borrow Aristotle's example, a ship captain throwing his cargo overboard to save his ship from a storm acts under duress, not because another agent is threatening him, but because the world has rendered doing so the only acceptable option. Likewise, a woman desperate for money may sell sexual services because the starvation of her children is an unacceptable option. Think of Dostoevsky. When the threat in question is agential, it may be violent or non-violent. If some cretin threatens to ruin a man's reputation if he refuses to give him money, he puts the victim under duress. But he doesn't do so by threatening any kind of physical violence. And then when you consider the case of rape, it would be a violent threat usually, and certainly is agential. What matters here is whether the threat posed by certain harms, be they violent and agential, or non-violent and non-agential, is enough to put the agent threatened in a state whereby her subsequent acts count as non-voluntary. Whether all of non-voluntary sex is rape is another question, and we are concerned with refuting the opposite claim, that all rape is non-voluntary sex. Indeed, building the absence of duress into the definition of voluntariness helps us avoid the alleged problem with the revisionist view. It would be controversial to claim that a woman threatened with extreme violence has sex voluntarily, even if she deliberately chooses sex over other possibilities. When one fies, simply having other options to fying does not make fying voluntary. One must, for Hyman, have other acceptable options. Crucially, however, determining whether an agent has acceptable alternatives isn't merely a matter of determining whether the threat is sufficiently unpleasant or harmful or disliked. According to any reasonable view, duress has limits, and exposing these limits exposes the cracks in Hyman's account. See, he goes on, I go on to talk a little bit more about this, but the concept's pretty simple. So, duress is an excuse in the law, but note that even Widgery earlier said it's not an excuse for everything. It's not, for instance, an excuse for murder. So if I put a gun to your head and say, you need to commit this murder or treason or whatever, or I'll shoot you, the law says, well, sorry, you're in a tough spot, but if you do commit murder under this threat, you don't have an excuse. You'll still go to prison. You just have to accept your fate and not murder, and I guess potentially get shot by your threatener. So we have to, when we're building an account of duress, we have to take into account both the level of the threat and the stakes. So here, a ridiculous case would be, that if you don't, eat the Mona Lisa, I'll call you a demeaning name. Well, if you're caught doing that, even though that's not murder, he said, well, Nathan was going to call me a mean name unless I did that. People would think, well, that's really not a very good excuse. You're still going to prison, buddy. Because in that case, the threat is quite small, being called a mean name, and the stakes are quite high, the loss of a precious artistic work. So really what you need for duress to be a good excuse is you need both, you need the stakes to be low enough, you need the stakes to be lower than the threat, roughly speaking. You need like a big enough threat to compensate for whatever the stakes are, and as the stakes rise, the threat needs to rise commensurately, or the duress excuse goes away. And that's not just good sense, that's also the law. At least it's the law with respect to treason and murder, and maybe some other things. So, here's a case. So let's inhabit Hyman's picture. So, on his view, right, choice is not the foundation of moral responsibility. It's just whatever lacks compulsion, in this case duress, or ignorance. So here's a case. Anna is committed to loving her husband faithfully. She highly values her sexual integrity and considers the sexual act to be deeply important. Furthermore, she has a medical condition that could very well kill her and leave her dependents helpless should she get pregnant. Since Anna is morally opposed to abortion and lives in a country in which abortion is illegal, she normally takes precautions to avoid pregnancy. However, her husband is away, she isn't on the pill, and she has not taken any other precautions today. Into her apartment walks Kyle, who demands that she have sex with him and threatens to beat her into submission if she refuses. She says that if he tries, she'll scream, and the policeman living next door will arrive to stop him in 15 seconds. Kyle acknowledges that he couldn't have sex with Anna if she screamed, but he could moderately beat her in 15 seconds. Anna, though not a bad person, greatly fears being beaten. Though she decides she should and could resist him, even at the risk of moderate abuse, she gives in. So, in this case, does Anna have sex voluntarily? Well, in the kind of gerrymandered version of the Nicomachean view that Hyman saddles me with, well, she had a choice and she made the wrong one, so yes. The problem is, it's also true on his view that she has sex voluntarily. Why? Because the threat is low, or not low, moderate. The threat is, getting sort of slapped about for 15 seconds. And if that sounds too high, lower it to 10 or to 5 or whatever you think counts as a merely moderate threat. And the stakes, very, very high. Her life, her children's lives, whatever. So, because he acknowledges the role that stakes have in undercutting duress, he has to acknowledge that this counts as a voluntary act for Anna. Or at least he shouldn't have to acknowledge that. That's based on what he says. Well, if that's right, then his view is just as repugnant, so to speak, as everybody else's. Because, again, he thinks there's a huge amount that rides on this voluntariness condition instead of like other considerations. So if his reasoning earlier is correct, then he would be committed to saying, well, yeah, Kyle shouldn't go to prison. He has an excuse. She slept with him voluntarily. So it's a tu quoque problem with Hyman's account. It turns out that basically every account has this problem of say, somewhat errant victims. So you can think of plenty of other cases. You can think of, people who let their children go into unsafe parts of the city, or other vulnerable people go into unsafe neighborhoods. If something happens to them, the person that hurts them is of course guilty. It's no excuse. But they're not without some blame themselves. They behaved really imprudently, or in Anna's case, slightly cowardly. And again, the sexual case is important. If you think that those sorts of cases are special, then think of conscription. Instead of Kyle and Anna, it's Sergei and Dmitri, and Sergei wants Dmitri to go fight in this unjust war, and which is really bad, and then gives him sort of a small threat. I'll ruin your reputation or whatever, or I'll fine you or whatever. And on Hyman's view, he has to say, well, if the stakes are sufficiently high, then we have voluntariness back. So Hyman's view is no better than the standard view. And one way to get over that is just to give up on the project of making this voluntariness concept, which is important in law, so rigid that it defines every crime of force, every crime of manipulation, and you just say, well, look, in the Anna Kyle case, maybe it's rape, maybe it's equally bad sexual extortion, but what matters is the quality of the will, not of the victim, but of the perpetrator. And regardless of of what the victim says or what responsibilities the victim may have, the fault lies with the perpetrator, and the fault is commensurate to his quality of will and his choices, and not sort of technical legal gotcha concepts like voluntariness, which no one really uses in real life anyway. So I've got a lot more on the legal aspect, but it's already 2:40, and I'm going to wrap up and let Dominic take over. So thank you very much.
Thanks so much, Nathan. This is the start of, I hope, a bit of a long project, which is to ask whether there's a welcome space for political theory within natural law theory. As you know, natural law theory grows out of what we'd consider philosophy, and also law, legal theory, as well as theology. So we don't have it within political theory, which gives political theory accounts of state of nature detached from the natural law tradition. So I want to ask if we can have a political theory of natural law, whether that would be welcome. And so the first problem in this project is that natural law theory is it seems to be quite a complete account. And so, whereas the nature of politics is to reform or make better what is out of order. So I'm dealing with this problem. I hope it's of interest. So the natural law tradition provides a complete account of law in a harmoniously connects its theory of law to practical initiation and application of positive law. And so it's the true inventor of the concept of positive law as distinctly authoritative. So as such, a natural law theory of the nature of law seeks both to give an account of the facticity of law and to answer the questions that remain central to understanding law. John Finnis explains, the term positive law was put into wide philosophical circulation first by Aquinas, and natural law theories of his kind share or at least make no effort to deny many or virtually all positivist theses, except of course the bare thesis that natural law theories are mistaken, or the thesis that a norm is the content of an act of will. Natural law theory accepts that law can be considered and spoken of both as a sheer social fact of power and practice, and as a set of reasons for action that can be and often are sound as reasons, and therefore normative for reasonable people addressed by them. The dual character of positive law is presupposed by the well-known slogan, "Unjust laws are not laws." Properly understood, that slogan indicates why, unless based upon some skeptical denial that there are any sound reasons for action, a denial which can be set aside because defending it is self-refuting, positivist opposition to natural law theories is pointless, that is, redundant. What positivists characteristically see as realities are to be affirmed are already affirmed by natural law theory. And what they characteristically see as illusions to be dispelled are no part of natural law theory. So natural law theory offers an understanding of the central case of law as, quote, the law and legal system of a complete community purporting to have authority to provide comprehensive and supreme direction for human behavior in that community, and to grant legal validity to all other normative arrangements affecting the members of that community. So the picture of legal social order is thus complete, I mean, joining the practical and the theoretical to establish the cohesiveness and the authoritativeness of normative arrangements. But the completeness is only in the sense of law's ordering, seen on its own terms. At least that's my view. It's not a complete ethical account, which would have to account for being and goodness prior to legality, and it does not act as a complete account in terms of the need to establish the virtues for habitual realization of the good, or what are the virtues, or why the virtues, why we need the virtues. And it is also not a complete political account, I will try to put forward in this paper. So first, an important preliminary observation. Identifying incompleteness or completeness in natural law theory could be a task that can benefit through analogy to Kurt Gödel's incompleteness theorems as applied to mathematics and logic. So Gödel's theorems establish that formal theorems are limited in provability because there are always statements within them that can be neither proved nor disproved by the theorems themselves. So a system is only considered complete if for every statement of language of the system, either the statement or its negation can be derived, i.e. proved, in the system. So theories of legal positivism are various attempts at a more complete account of law through reliance on this very same approach, reliance on analytic truths only. So these are truths in virtue of their meaning only, such as all bachelors are unmarried. Legal positivistic accounts vary in their level of reliance on analytic truths, but insofar as they are reliant, they purport completeness, in that they contain claims and sentences that can only be proved by the theory itself. So asking a legal positivist what is law, in order to maintain completeness, they must provide a response that is true by nature of the positivistic account itself. So, for example, law is law, or law is the union of primary and secondary rules, or law is what the law does, or law is what the law says. Or else they enter into a situation in which completeness is compromised, as they provide a response that depends on self-evident observations that lie outside the theory and therefore cannot be proven by the theory. So, for example, when they might say, law is what the state says is law. For example, laws are the commands of a sovereign. Or law is what judges interpret as law. So which is a grounding of meaning in self-evident observational truth that in fact means the theory is actually an outgrowth of the natural law tradition and takes law as a granting of legal validity to all normative arrangements for which it is not the sole source. The law is not the sole source. When legal positivists make this step, what I would describe as a step backwards into the tradition, they usually do so immaturely, however, taking one or two observations of actual normative arrangements, whereas natural law theory takes all. But their deficiencies are understandable because the real goal is to eliminate and if not hide, the self-evident truths that are necessary for the functioning of a legal system as a system, by trying to provide a complete account on its own terms of proof of validity. So a legal positivist's acceptance of one or two normative arrangements is a compromise, as limited as possible, to be as analytic as possible. For their part, natural law theorists are also, however, not obsessed with pointing out self-evident truths, but this is for very different reasons. They do so, but they're not obsessed with it. So what typically matters to most to natural law jurisprudence is understanding the whole system of law in conversation with morality, not causally establishing the sine qua non of a legal system. So that's actually the same in mathematics, whereby the topic of maths can be gamefully pursued and enjoyed even though its incompleteness is apparent. The incompleteness does not mean that one must focus exclusively on the aspects of its functioning that rely on self-evident truths. The overall system enjoys explanatory force that is still greater than the self-evident truths it relies on, and hence insightful as a unity of order in its full extension. Application of pseudo-Occam's razor makes a grave mistake in this situation by determining certain elements or assumptions as essential to the explanation, so in this case, self-evident truths, and then holding those as the only real elements worth applying to other similar phenomena in order to arrive at a general explanation. A typical example for the study of law is to say that the law is what the sovereign says is law, a positivistic failed attempt to minimize interaction with normative commitments that lie outside of a legal system. And then, once they've done that minimalist move, or a pseudo-Occam's razor move, when they encounter any new legal system, they ask where the sovereign is, and if there's not one, then they say there is no legal system. Natural law theory, on the other hand, openly exhibits synthetic truths that are true both because of what they mean and because of the way the world is. It is thus engaged in the debate on the rooting of legal systems within the reality of human interpersonal morality, seeking a complete explanation, not as an isolated or isolatable system, so not an explanation of how a system would work without people, but transparently in line with the way the world is, the way humans are in their normative coordinations. It generates principles of legality that are objective, but that is not to say detachable from the human condition, because they're based on the particular goods of human nature. So the nature of completeness within the natural law theory does not succumb to Gödel's incompleteness theorems, because a natural law theory derives its statements from the entirety of creation, which is a complete act, a single act. And here, reference summa contra gentiles. It is also, however, not reducible to the self-evident truths external to its system, because it expresses an emergent system of legally valid normative coordination, which is explanatory of the realities of community life at a level of comprehensiveness greater than the explanatory force of those self-evident truths seen in isolation. The central case of law is thus the legal system of a complete community, natural law theory is supportive of, indeed inspired by, Aristotle's approach to the polis as a self-sufficient community that is more than the sum of its parts. So, as Aristotle explains in the Politics, when we come to the final and perfect association formed from a number of villages, we have already reached the polis. This may be said to have reached the height of full self-sufficiency, or rather we may say that while it comes into existence for the sake of mere life, it exists for the sake of a good life. For this reason, every city exists by nature, just as did the earlier associations from which it grew. It is the end or consummation to which those associations move, and the nature of things consists in the end or consummation. For what each thing is, when its growth is completed, we call the nature of that thing, whether it be a man or a horse or a family. Again, the end or final cause is the best, and self-sufficiency is both the end and the best. From these considerations, it is evident that a city belongs to the class of things that exist by nature, and that man is by nature a political animal. Some mistake that self-sufficiency for indicating a constitution independent of the parts of society in the sense of being able to exist independently of individual citizens. That is clear in the social contract accounts of Hobbes and Rousseau, which produce a new being on the level of ontology in the state by means of unity of wills. In treating the resulting state as an omnipotent corporate person, subsequent political theory and jurisprudence affirms sovereignty as a concept in its own right that can, in theory, apply to anything, and perhaps apply back to the individual as liberalism's last laugh. The mistake, if it is indeed an interpretive mistake rather than simply just an alternative design, lies in taking Aristotle's notion of self-sufficiency to pertain to a detachable institutionalization of the state. So in this sense, the idea of self-sufficiency is taken to mean something like complete in Gödel's sense, and that the state can produce a language whereby every statement or its negation can be proved or derived in the system. For this reason, it's of necessity that for Hobbes, the sovereign is the final judge, because the application of laws needs finality within the system itself. Natural law's endorsement, on the other hand, of the idea of conscientious objection, or more generally its understanding of law as making legally valid the normative obligations that exist in society, means natural law theory is, by contrast, avowedly non-reliant on a sovereign able to manage his or her own morality. Aristotle's notion of self-sufficiency is better understood as the lacking of nothing in making full human development possible. So, as explained in Oxford University Press notes to the earlier quoted section, the height of self-sufficiency does not mean that the polis produces everything that it needs, but rather that it has everything necessary for its well-being. Aristotle defined self-sufficiency in the Nicomachean Ethics as that which by and of itself makes life desirable and lacking in nothing. The focus on realizing an arrangement in which citizens lack nothing, which at the level of the body politic means that they enjoy the civic friendship that constitutes justice and harmony for the meeting of collective needs, the polis has everything necessary for its well-being, which is the flourishing of all its members. Now, part of what is going on here is that although the polis exhibits a greater level of self-sufficiency than the individual, family, or village, there is no change in substance from the individual as he enters into full participation in the polis. So the substantial unity of the person, for example, his formal cause as an individual soul, is not gained or abandoned in the growth of his community into a polis. Rather, the substantial unity of being a full and complete human being is maintained throughout, just as death continues to play its role at the level of the individual as an ender of his substantial unity of being through the ending of life and the beginning of the process of decay and disintegration. Aristotle is therefore performing a very difficult intellectual task of describing the greater ability of a polis to meet the needs of individuals in line with their teloi for happiness, while knowing that the newfound order does not change the substance of being for any given individual. His solution is an admission that the polis is incomplete, in the sense that it is nothing without its members, not least because its telos would be unintelligible. Any account of completeness requires the synthetic truth of humans acting out their nature, which is to say that the polis is not complete as an omnipotent corporate person that exists by its own will. It is more than the sum of its parts, in the manner of able to fulfill human needs, but still dependent on those parts. It is causal in line with the teloi of its citizens. Causal because we're not talking about chronological occurrence of first there being a community and then they're forming a state, which is a typical mistake in state of nature accounts. But that the emergence of the state is concurrent with the realization of the people as a self-sufficient community in line with the exercise and fulfillment of human nature. As Aristotle explains at the very start of the Politics, observation shows us first that every polis is a species of association, and secondly that all associations come into being for the sake of some good, for all men to do all their acts with a view to achieving something which is, in their view, a good. It is clear, therefore, that all associations aim at some good, and that the particular association which is the most sovereign of all, and includes all the rest, will pursue this aim most, and will thus be directed to the most sovereign of all goods. The most sovereign and inclusive association is the polis, as it is called, or the political association. The unity of the legal system is the unity of the political community, and citizens may need to risk death in defense of others, but neither of these facts mean that the polis in its ascendancy replaces its members' continued exercise of free agency, nor their continued pursuit of virtue as part of a personal habituation towards happiness. So as argued elsewhere, the central case method understands law as ordered internally in its practical reasonableness, without being the only means for pursuing the common good, which is an acknowledgement that the task of prudentially mastering the relationship of means to ends for society's fruitful coordination is going to stay with us, in contrast to utopian accounts that think the challenge of ordering society towards the common good can be settled once and for all. As such, it is appropriate that Finnis's account of the common good maintains that practical reasonableness is not only a way of understanding law's internal ordering, but also a basic good that must be protected at the level of the individual human person. So thus far we have established that, in contrast to examples of legal positivism, natural law theory 1 does not purport to be a complete natural law theory does not purport to be complete as an analytic truth. 2, but is complete as a synthetic truth of accepting the evidence of human nature to be the basis of the central case of law as the ordering of the community through the imparting of legal validity to its normative arrangements. And 3, and yet does not purport to lay claim to an ontological emergence of the state in its self-sufficiency, but rather interprets that self-sufficiency in line with the needs and flourishing of individual members who retain, if not enhance, their moral freedom through membership. As such, natural law theory does not give a political account of the way institutions of government should be constituted and run, nor does it say what normative arrangements more generally are needed. Now this may shock some because natural law theory is typically very vocal of the natural rights and duties that are needed to maintain good law, and in turn the overall flourishing of the polis. So it is assumed that the advocacy of what is moral in these cases amounts to an advocacy of normative arrangements. However, on the contrary, one can also point to indeterminacy purposefully built into natural law accounts for their understanding of political necessities. While some normative arrangements are effectively essential for any functioning community, like not murdering or not lying, assuming for the sake of argument evil intent and effect in all of those actions, and even though a universally applicable account of the basic goods to our nature is readily attainable by all societies, these are still vague and unsophisticated accounts compared to the details of all normative arrangements that typically form the body politic. And the extras are not just extras, they're not superfluous. Indeed, while being variable according to circumstance, environment, and civic culture, we're talking about the very substance of a polis's normative arrangements, from manners to customs to mores to conventions to rules. The gap in accounting for normative arrangements, the arrangements of here and now, is the gap that needs to be filled by a natural law political theory. So having just shocked some by talking confidently about apparent deficiencies in natural law theory, this may now scare the same people because a common view of politics is that it engages with arbitrary instruments of coercion to bring about short-term measures. It seems dangerous, therefore, to attempt a political theory of natural law, even more so to claim that a natural law political doctrine can and should be implemented by states as part of their pursuit of the common good. Can we not just stop at the level of ethical fundamentals to our nature, combined with an account of law as granting legal validity to a complete community's normative arrangements? Unfortunately, no. Because we thinkers of natural law are citizens too, and a denial of our political nature acts as de facto affirmation of an incompleteness to the theory overall by making it an analytic truth only, a show of internal consistency of meaning, not a synthetic truth, not a comprehensive truth of meaning and reality joined. Our political nature is a self-evident truth of our nature that is unavoidable for any account of society's normative ordering. As Finnis states, politics signifies the field of action and discourse to do with the affairs of complete communities. This is stated shortly before his definition of the central case of law in Natural Law and Natural Rights, and so indicates that both politics and law are concerned with the complete community in their focal meaning, maintaining the space for a natural law political theory in order to perhaps account for the normativity of social relations that law provides comprehensive and supreme direction of. So that's as far as I've got in terms of trying to think through the completeness of the natural law account and its reliance on human nature, in turn requiring a reliance on explorations of our political nature, and that natural law's supremacy given to law is in the way it enables our normative arrangements that still therefore need to be accounted for, and that is in the domain of politics and political theory in part. So what I hope to turn to future is trying to look at what would be the central tenets of a political theory of natural law as it pertains to the question of where can we have assured advice on the normative arrangements that are in harmony with the natural law. And so I just want to indicate 4 of these by way of close, although I haven't gone into this much. So as a political theory, it would have to affirm, 1, that human nature is not malleable. 2, it would have to affirm that normative arrangements are the normal practice of our human nature. So it means that legal validity is not about confirming the expansion or the efficiency of some normative arrangements, but is also in the domain of stating which normative arrangements should have lesser role within the law. So what norms are not to be made legal. Thirdly, politics would have to be a space for the development of customs to mores, to rights and responsibilities. That development within institutions and cultures of the refinement of customs to rules would be an essential part of political theory. And fourthly, even though human nature is not malleable, there would have to be an account of the way in which virtues are affected by those around us, and the place of institutional design and habits or collective virtues, social virtues, civic virtues, for the realization of the fulfillment of human development through the self-sufficient polis. Thank you.
Could you unmute yourself, Arnaud?
Okay. Did you see the PowerPoint?
Could you share your screen? If you share your screen, I can accept it.
Did you see the PowerPoint? No? No.
Do you have it, how we can share a screen? Oh. Hold on, 1 second. Let me see if I can fix this. Maybe we'll see it. Yeah, we see it now. If you start the presentation, we can see it.
Okay. Okay, I can start. Okay.
It disappeared now. Oh, whoa.
Oh, wow. Yeah, you see it. Yeah, you see
not a complete set.
Did you see the PowerPoint?
Yes, but could you try to start the presentation?
Okay, starts.
Oh, sorry, 1 moment. The circus is moving back and forth outside.
Starts. Okay. I start. Okay. Thanks, Peter, for welcoming us. It's a great regret for me to don't be here physically. As I'm the last speaker, I will try to keep this short. So as now, try your patience. I will like by saying 3 things. First of all, even so, I have already gave multiple lectures in conference in France. I am not familiar with international conferences. I am not used to giving talk in English. I try to do my best. Please bear with me. Secondly, this presentation will focus on slavery, contrary to what the initial might have suggested. Finally, oral intervention is based on more detailed article written previously and which we include in the number 3 of Revue de Philosophie Droit, linked to the theme of consent. I apologize if my argument is simplified due to the time limitation. The final title of this intervention should also be changed to make this communication more relevant. The new title we can choose perhaps is the arguments, you can see on the screen, the arguments of consent in justification of slavery within the modern school of natural law. In the light of few passages from the school of modern natural law, I will show that curiously the argument of consent as it was put forward to justify slavery. Let's begin. As Olivier Grenouillot explains in 2021 is his last masterpiece, Christianisme et Esclavage, Christianity and Slavery, in the 5th century, even before the theorists of political freedom challenged absolutism, freedom was the dominant principle of private law in the West. After a first prohibition of slavery between the Christian at the end of the Middle Age, the abolitionist tendency of the institution of slavery emerged very late in Europe and by no means unanimous in the 18th century Enlightenment. While the thesis of man's natural freedom was being...
Oh no, sorry, we can hear you, but have you changed the slides? Have you started?
Yes, yes, it's
Okay,
the first slide. While the thesis of man's natural freedom was being disseminated, slavery theory were able to benefit from a number of especially modern arguments between the 17th and the 19th century. In the ancient Greece, and right up to some of the modern higher, the alienation of workers was based on the thesis of natural authority or slavery by nature. Aristotle, often presented as the founder of this theory, reminds us that since natural inequality exists, they must have consequences in society. Unlike the Peripateticians, the Stoics and Roman jurisconsult believes in the natural freedom of all men. For Romans, slavery stems from the notion of just war. If war is just, so are its consequences. To my knowledge, no new justification for slavery has been found in medieval civil law. During the Middle Age, Bracton begins his De Legibus by taking up this theory of Roman law. As he says, I quote, slavery can be defined as an institution of the jus gentium, by which, contrary to its nature, someone is subjected to the power of another. End of quote. The institution of slavery was supported in both the Old and New Testament, as well in Roman law, on the teaching of the Church Father, with the exception of Gregory of Nyssa. Slavery was a legitimate institution, but slaves share a common humanity with the free people. They should therefore be treated humanly and fairly, and manumission was seen as a charitable, meritorious act.
And Noel, could you go to the next slide?
Oh, okay. It's for after. It's my introduction. As the French historian Jean-Marie Salamito, specialist of the Church Father, explains, I quote, "The New Testament recognized slavery as a contingent fact without ever providing any theological foundation for it. Contrary to popular belief, Augustine does not justify slavery. He sees it as a pure violation of Creator's wills." End of quote. In the Father's doctrine, there is no choice, according to Jean-Marie Salamito, of the Aristotelian idea of natural slavery. They took for granted the Stoic doctrine transmitted to them by Cicero or Roman law. A key text of Justinian Institut declared, I quote, "By natural law, all men were born free, but afterwards slavery came in by the law of nation." End of quote. Let's come now to the doctrine of natural law. In modern natural law, the justification of slavery seems impossible since one of its basic postulates is the assertion of the individual's mastery over himself. The dominion over his life, inscribed in nature, justify the individual's power over external goods. Grotius builds the whole of his later reasoning on this first postulate, which is that man has sovereignty over himself. This original power which the jurists draw far-reaching consequences, no longer rest on any theological foundation, no enhancement depends of the political community, sorry, but on the fact that man is instituted by himself through his work as master and possessor of his existence and his goods. Yet, as explained Brian Tierney, the English historian in his last book, Law and Liberty, I quote, the modern school of natural law does not condemn slavery without ambiguity. On the contrary, it seems to provide the ultimate justification for it, end of quote. To my knowledge, the author of modern natural law, such as Grotius and Pufendorf, were the first to use the argument of the conscience to give form of legitimacy to the domination of the slave masters. This explanation is destined to have a great success, given that it goes with the evolution of modern morality. Let's start returning to the text and then show that the conscience arguments were be found in other authors to justify concrete practice of slavery. As we say in the modern just naturalist approach, the thesis of natural slavery, as formulated by Aristotle, is no longer understandable. The equality for all men under natural law make natural slavery inconceivable. As Pufendorf put it, I quote, God is not immediately the author of this condition, end of quote. After Grotius explains that the new justification for slavery can only be conversion. Pufendorf also shows that all man can profit from a definitive renunciation to his natural freedom. Pufendorf, on the text on the screen, Pufendorf on the book 7 of De Jure Naturae Gentium on the law of nature and nation can explain why wage labor precede slavery. Sorry. You can see the text on the screen. I quote Pufendorf. In our judgment, the origin of servitude ought thus to be traced out in the early age of the world, when a man began to quiet their primitive plainness and simplicity to cultivate the method of living and enlarge their fortune and possession. It is very likely the wiser and the richer sort invited those of less part and less wealth to assist them in their business for hire. Afterward, when both parties found their benefit in their way of proceeding, the minor tribes were by degree persuaded to join themselves perpetual member to the family of the greater under this condition that the latter should engage to supply food and help convenience of living, and the former should bind themselves to undertake all proper labor and employment, as the patron should direct. So that's the first servitude owing to the voluntary consent of the poorer and more helped persons, and is founded upon that common form of contract. End of quote. Servants enter forever into the family, and the farmers. Thus, servitude was first established by the free consent of the party and by a contract to do so that you would be given. Let's make two comments. Firstly, this justification of slavery is new. Voluntary servitude was not the subject for the Roman law. And author like Barberac is well aware of this and reminds us, Barberac is a French traductor of Pufendorf, reminds us accurately. Slavery is not based on the law of war, as the Romans maintained, but on the vital dynamism. Secondly, Pufendorf reduced the violence at the roots of domination. For some men, it is master of relying on others by convention just to guarantee their subsistence. In different parts of his book, Pufendorf put forward similar argument to justify slavery. If man is master of himself, he can annihilate himself and sell himself into slavery as he sees fit. In the book 7 of De Jure Naturae Gentium, the German jurist explains, we can, by voluntary submission, relinquish to someone who accepts renunciation the right we have to fully dispose of our freedom and natural power. In this way, a man who agrees to be a slave truly confer on me the authority of master over him. End of quote. To establish the authority of master on the subjection of servants, as he said, Pufendorf replaces servitude based on the Roman Judentum with a more or less implicit economic pact. Slavery is based on economic pact for survival. To explain his reasoning to a European public which no longer has slave in front of his eyes, he didn't hesitate to compare slave to day laborers and apprentices, as he explained, I quote, among whom those called apprentices in England approached the condition of slaves during the time of their apprenticeship last. Sorry. End of quote. No one is born as a slave, but we can choose to become one because this is not the result of the law of climate as Montesquieu pointed out, but of the law of economic. So contrary to the genealogy of Roman servitude, slavery is merely a sophistication of wage labor. The origin of slavery is, so to speak, pacified, since, according to Pufendorf, it simply seems that rich, intelligent people hired ignorant, unaccommodating people to work for them in exchange for a certain wage. If it's true that the consent argument is reversible, since if the slave is presumed to have consent, it is conceivable that he may wish to leave this condition. That said, we mustn't be naive, as the consent argument is a very practical way of supporting a system of domination. Pufendorf's argument is not purely academic, and we can found among jurists in different legal traditions. As William Blackstone says, I quote, now it lays down that a slave or negro, the instant he land in England, become a free man, that is, the law will protect him in enjoyment of his person, his liberty, and his property. This is a principle, but yet, with regard to any right which the master may have acquired by contract or the like to the perpetual service, they will remain exactly in the same as before, for this is no more than the same state of subjection for life, which every apprentice submit, so for the space of even years or sometime for longer term. It's end of quote. It's interesting to note that William Blackstone used exactly the same comparison as Pufendorf between wage labor and slavery. Thus, the natural freedom of black people is not called in every text, but what is put forward is the fact that they are placed in other law instead of dependence, which leads them to be willing to accept domination over their own person. I take another example. In France, David Duval de Saint-Nanon, a spokesman for Guadeloupe slavers, in his speech called Discours sur l'esclavage des nègres in 1786, can explain, I quote, originally, the person who has become a slave is free, meaning that none of his fellow human being has the right to say to him, you belong to me, you are my thing. He belongs to no man rather than to another, but he is really the slave of his needs, which forces him to sell his time to whoever can buy it, and ultimately to sell himself. End of quote. David Duval de Saint-Nanon is a French author who is familiar with the actual practices in the 18th century, the practice of slavery. He claimed to be against, but he defended it for economic reasons. He defended it with the arguments in vogue at the time. In the same text, David Duval de Saint-Nanon does not hesitate to compare the situation of slave with that day laborer in Europe who are dependent on their need. Sorry. Here comes the conclusion. According Simone Goyard-Fabre, a French philosopher of law, Pufendorf updating of consent established the link between the dignity of the human being and his fundamental freedom that we find by Kant. The arguments of the use of self-ownership consent and of the freedom of contract are used as the unique base and the limit of human dignity. Yet, basing human dignity solely on the capacity to consent is not without its difficulties. Development in medicine and information technology, and in particular, the issue of data, raise the very question on the limit of consent in determining what is just or unjust. Relying on a certain interpretation of Lockean self-ownership, highly debatable, as this author did not share Pufendorf's thesis and reject the notion of pact of slavery, the libertarian approach maintains that the best way to protect the human body is to draw a legal attitude, is to draw a legal consequence of self-ownership, considering, for example, that the question of data protection is purely a matter of intellectual property at consent. A question of consent, the consent, and not a political question. That's the same reasoning that Pierre Berger, a great businessman in French media, uses when he says that lending his belly for a surrogate mother is the same thing than lending his arm for any worker. Today, making people's civil statute and professional statute more flexible is like two sides of the same coin. Each individual is seen as a sovereign who found himself on whose fate depends in theory on his ability to assert himself as a master depend on no one. Those who fail to assert themselves as a master are mechanically relegated to a lower category of humanity, that's of people who are nothing and have no choice but to serve the people who succeed, to use Emmanuel Macron's currently President of France words. The attitude of modern just naturalists contrasts with the dependence of humanity based on requirements that are constitutive of human nature, which was that of the Dominican jurist of the second scholastic period. For an author like Francisco de Victoria or Bartolomé de las Casas, human dignity depends neither on the arbitrariness of the individual nor on social recognition, but it's an objective reality. The duty that flow from recognition of the dignity of other and the corresponding rights that flow from it, therefore have a concrete, objective content based on common human nature. Without this objective reference, the concept of dignity is in reality subject to arbitrariness and the most diverse power relations. Thanks for your attention.
Arnaud?
Oh, yes. You see me?
Oh, we have the infinite regress again. Look at that. Love it. I see you and little you and smaller you going into infinity. Thank you for that. We have a break now, and
Okay.
then we come, and then we will have questions and answers. I can leave this line open if you want, and you could listen to the discussion in a half an hour. Yeah. Okay.
Okay.
Okay. I'll leave the line open. I'll mute it for now and turn it back on. Okay.
Okay.
Yeah. Thank you. Okay, so friends, we will have a break for tea at the same place. If anyone wants to traipse up the Pusey Tower with me, I can probably 10 of us is anyone else from Pusey here? That's 10. David, do you think 10 is too many?
You can get 10 up there, but
we'll do it in two groups of
friends.
How many people are interested in going up to Pusey Tower? 1, 2, 3, 4, 5. Okay, so why don't we split you in two groups? So
it's a question of weight.
Okay, put your hands back up. No. It's like it's a narrow staircase, and the area to stand on is just not so big. That's all. But, okay, so put your hand up again. Okay, I'm gonna do A B A B A B A B.
I need to prep remarks. Can you show me after as a?
Sure.
Thank you.
So group A, grab coffee. I'll collect you in 10 minutes. Group B, I'll collect you in 20 minutes. We'll be back here in 30 minutes. Yeah. John, and your ma'am, your name again? Eveline. Would you mind not sitting in the back row so we can have a nice conversation? I already kicked these nice people out of the back row. So.
I'll come to the front.
All right. And I think
spit questions in there.
Yes, good.
It's a bit.
Oh, you want to close? Okay, so let's start with the most recent session and any questions you've had about it, and then anything from the rest of the day is also fair game. So why don't we do about 20 minutes on the most recent session? You have to be out at 5:30, right? Okay, so we'll do about 20 minutes or so on the most recent session, and then we'll continue on what's transpired for the rest of the day leading up to now. So who would like to jump in with it's a discussion rather than Q&A. I'll ask you something, Nathan.
Sure.
Why don't you deal with concepts, or maybe you do elsewhere, like consent or assent? And I ask because, these are words that share this, sensu. They share a word that can mean meaning or understanding. And when we have positive signs that someone else has understood, we can understand better, perhaps, whether we're going to harm someone or not by our actions, or whether we're being harmed or not by the actions of others. And the legal principle behind this is that consent removes harm, which is why a boxing match isn't an attempted murder.
Well, I'm interested in the foundation of moral responsibility, and I argue that it's choice. It's not, though, as if that exhausts the whole field. When we think about consent or assent, we're not just thinking about the voluntary or the free or the sort of thing you could be morally responsible for. We're also doing something epistemic. So, how does the law know that you're free in this context, or how does the law know that you've taken on a certain kind of responsibility? Well, you have to say so. And sometimes you're capable of saying so, and sometimes you're not. So certain kinds of consent or apparent consent don't count, right? Maybe
some do, though, because silence can imply consent in many cases, especially in partnership arrangements. Silence implies consent is one of the principles of contract law.
Sure, but consent. Generally, in order to be consent, it has to be free.
An active sign.
Ultimately what we're looking for is choice still. And what makes consent interesting is its relationship with choice. I don't have anything in particular to say about it as a concept beyond that. But I think the position I defend is about the primacy of choice.
There's a bibliographical, I'll just give one little way that you can, and then I'll come to you. There's a book by an Australian lawyer that I think is only available in the English-speaking world in the Oriel College library, and Paul might have checked it out after I told him about this, called The Law of Consent. And what this judge argues, and judges in the English-speaking world are the authorities on the law for the most part, except in mixed systems like the States and others. So when a judge writes a book, it typically has the force of learned legal opinion. He argues there is no consistent doctrine of consent in the areas of different areas of English law. There's none, which might give you more weight to your point that it's a much harder concept, a much more difficult area of human endeavor to pin down than what you're chasing down. So maybe that book might be helpful.
The law is great, but it's a blunt instrument. I mean, questions of moral guilt are in some ways less complicated and in other ways more. They're less complicated in that they don't have to. We don't always have to get to an answer. Was what that guy did really motivated by envy? Well, a perfectly fine answer is I don't know. The law can't be like that. Well, it can in the case of envy. It can in the case of envy. But in a lot of cases, it just has to deliver a verdict, or society collapses. you spoke earlier about how silence implies consent. Of course, that's not true. It doesn't always imply consent.
No, in some cases it does.
In some cases in the law, it does. And yes, I'm sure in some cases in real life it does. You sitting there passively sometimes does indicate in ordinary situations that you agree. But we're doing different things, and we shouldn't expect too much of the law, because the law isn't just about being fair, it's also about being stable and keeping society from tearing itself apart.
I wanted to put a case to you, a real one. It's called Rothenburg, a city in Germany. Rothenburg cannibal case.
Oh no.
Oh, I think I know this case. It's foul.
It's the penis eater.
You know the case, or do I have to sum it up?
As I understand the case, someone hired somebody to eat him.
Yeah, and someone published in the newspaper an offer saying, well, if someone wants me to kill, mutilate, and then eat him, just let me know.
Yeah.
And many people answered, saying, well, I'm interested by this offer.
I think the first thing this shows is there's something deeply wrong with the German psyche.
Yeah. No non-Germans answered.
Yeah, but you know that case can be transposed to less dramatical cases. And the fact is that on this point there was real consent. Someone who knew exactly what was expected.
He signed a contract too, didn't he? And made a video recording of himself.
Yes, they made a
consenting.
video, but I don't know if he signed a contract. But the fact is that to protect himself, the cannibal managed to keep all evidence of the consent of the other party, and that was his line of defense, of course, before the criminal court, where he was brought afterwards, and that raises the question of the limits of consent, and that's why in the first session this morning I asked the question, well, liberty in your interaction with others is something, and liberty towards yourself is the same. And here the question is that the liberty of that guy to sacrifice himself, and will the other party protected by that content?
Look, I'm a brutal paternalist. I think the state absolutely ought to intervene in such cases, but that's of course not what you're asking. You're not asking whether that contract ought to have been legal, because maybe you are. I don't know. But whether that's the sort of thing over which one can give consent. I think I am committed to saying that. Look, I mean, perhaps the man who wanted to be eaten is mentally ill. This doesn't seem so far-fetched, and that might vitiate consent.
But let's assume that he's not mentally ill, because now we've got the same question in France with the draft legislation, with the draft bill on euthanasia.
I think probably that's a perfectly normal case of consent, and you might think, well, maybe the consent of the governed is not sufficient for just legality, and trying to gerrymander the concept of consent in such a way as to prevent such cases from becoming legal is one way to do it. But perhaps the more intellectually honest way is to say, this is a totally consensual relationship that ought still be stopped by the authorities. And perhaps the same thing goes for euthanasia.
John's indicating something you can do. If you have something small and on point, just do one of these and you can skip the queue and jump in, but it needs to be small and on point.
Just to very briefly defend the Germans, we just had a very similar major case in Britain, which involved very long prison sentences for basically fetishists who are consenting to extreme bodily mutilation for reasons of their own enjoyment. and it's a well-established principle in English criminal law that you can't consent to serious offences against a person. And so, what that does to English jurists who want euthanasia is something that people should use as an argument more.
Please.
Can I link this to Arnaud? Because I had a question about.
Do you want him to speak? We don't know if he's actually back.
Yeah, let's see if he is.
Arnaud, are you there? Why don't you make your point? You want to make your point? He might not come back though. Do you want to make your point and then we can
if he comes back, I'll make the point. Yeah, it's okay.
Would someone else like to jump in the discussion? Please.
Of course, natural law is reason, common sense, and it's not possible to have a discussion just on consent in the abstract. In the abstract, to consent to what? And a judgment on the content of what has been consented to. In Switzerland, we're even going so far, the Federal Court, by arguing that a contract, something is contractual, but if it is not just, if one party is able to say that it is outrageous, even after having signed it freely, in one case at least, the Federal Court has accepted to modify the contract, keep the contract with a reduction of the rent. It was
well, modern consumer protection legislation, by and large, functions on the same principle. And we didn't really get into it today, but there was a time in the 19th century when radical theories of the autonomy of the will influenced contract law. And the pushback was not to police contracts with morality, which is what the late scholastics had done and what Grotius ceased to do, but to have post facto corrections, like cool-off periods, right? Cool-off periods for house purchasing. Many of your countries probably have them, like 30 days, which doesn't invalidate the contract, but it can vitiate the terms of it if you realize you made a decision in the heat of the moment. And it presumes an asymmetry of bargaining between the parties that isn't always the case, but it presumes that the buyer is in the weaker position than the seller in these matters. And that's the way we've done it. So we still assume a radical autonomy of the will and that pacta nudus sunt servanda and all the rest, but then after the fact we try to clean it up when things go wrong.
But in German language, you have the expression sachgerecht, and the contrary, sachwidrig. Sachgerecht is for contract or for decision, justified intrinsically by the factual element. Sachwidrig is not justified, so it's content related. And for instance, in tax law, we work all the day with what is sachgerecht and sachwidrig. Tax evasion, all the doctrine of tax evasion is based on this concept. You look to the substance of the transaction. And if the substance is not all right, for instance, if you have selected a form to your contract, you have made, for instance, what should be an employment contract, you have organized this as a mandate formally, and the form is not in line with the substance, there is a doctrine that the form is sachwidrig. In theory, there's freedom to use any kind of contract, but it cannot be as far as being totally sachwidrig, contrary to anything which makes sense. And I guess for an issue like this one, we can use the same approach.
Can I push back on one thing about consent? I think your general principle is right that you've appealed to 3 or 4 times today, wherein very generic truths, like suum cuique or something like that, have a problem in that they're only wholly meaningful contextually. However, the rendering is meaningful because it involves a transmission of something or a communication of something from one person to another. With consent, there is something procedural about it because what it really means is that an interrogable after the fact. Did you agree on the thing? Yes, it was this. Did you agree on the price? Yes. Did you agree on the mode of transfer? No. Did you agree? And then you're asking, have these two minds come to the same meaning? And that principle, that type of thing should be present for certain kinds of contracts to be valid, I think, can stand on its own, irrespective of content.
Yeah.
Yes, the same way in the French contract law, you can have consent, but you also have an objective factor, which is that all the essential elements, objectively essential elements of the contract have to be defined, determined, or at least be indeterminable. And consent is fine and binding if applied to this minimum.
So no mistakes about the price or the thing or the mode of transfer or the owner or
Contract by contract, you have different essential elements.
Is this from Potier originally? Is it?
No, it comes from Potier, who distinguished artificialia, essentialia, naturalia, but now it's really in the statutes.
I interrupted. You were going to jump in.
Well, there's a tension, it seems, between liberty and justice, obviously, right? We want to say that, well, consent is not a purely utilitarian concept, that it does matter that you have at least some, you ought to have at least some latitude over your own life. And of course, sometimes people mess up and they consent to something wrong, or the contract becomes a grotesque violation of justice. And so you have so you point out this tension. My question, I guess, to the room is, can you explain away this tension in the following way? Always and everywhere where consent and justice conflict, the presumption should be that justice wins, except when the mechanisms you need to enforce justice make the world hell. So that you can't have the state litigating every single contract. You can't have the state examining every financial agreement to make sure that down to the last euro or dollar or pound it's fair. And what you need to bring about to make this happen would be a Stalinist hellscape. But that's all there is to say. It's a super reductive view, and it really undermines the importance of consent. It says, look, the only reason we give consent any shrift at all in its tension with justice is because what we need to do in order to make justice reign fully would be to bring about a totalitarian nightmare. But does anybody want to push back again? Does anybody want to defend consent on its own terms, or is it just? Yeah, go ahead. Yeah.
Well, which of its own terms?
So I'm saying consent has a role, but only because to fully make to immanentize the eschaton and to make everything perfectly just, you just make the world hell. But that's not giving consent much. It has no intrinsic value. All of its value is extrinsic.
Yeah. I think it has intrinsic value because it allows a really clear articulation of content that is specific to the persons involved, and to have a sort of guarantee of that as well. It actually allows each of us to make laws, individual private laws, between ourselves that are enforceable in courts if necessary, but in the normal practice don't need to be enforced because they're understood to rise to the level of legal facts and legal relations. That can have almost any content we want.
Who cares?
Well, I care a lot. I make these contracts all the time. I mean, this is it's how I live my life. It's how we live our lives. The kinds of transactions are everything from an informal agreement to work together on a project to a sale that happens outside of deeded goods informally to just think of all of these. And
it's very helpful and efficient, but I'm agreeing with that.
Yeah.
I agree about the extrinsic importance of consent in having a functioning economy and a society that isn't like some puritanical hellscape. We're in agreement. But what I guess what I'm asking is, is there any?
Yes.
Okay, go ahead. Yeah.
So if we didn't have consensual contract as the model of contracting, as we do in the modern world, which the Romans didn't, for instance, then we might have things like everyone having to go around and stipulate everything to one and say the same words, and have people witness that the same words have been said, so that there's some sort, which is the equivalent of a signature being signed on a piece of paper nowadays, or write everything down. I've lived a bit of my life in Poland. I have one Polish wife and 4 Polish kids. And a few Polish cars, and it's a great place. And everything is written down there because of what communism did. Because what couldn't be trusted was the ability of people to go around and say things to one another and keep their word on it. And so now contracts aren't really real until they're manifested on paper and physically, and that's extremely inefficient. It's grossly inefficient. And so what a consensualist doctrine gives us as a motivating way of us realizing that we have agreement that can rise to the level of legal reality and that level of seriousness, maybe be pursued in small claims court if necessary, is it gives us a reliable way to live our lives and to risk things and to engage with others without having to engage lawyers and much of anything else. At least in England and in the States, you and I could just sit down and write a contract on a napkin, or make an agreement and a handshake between us that could end up being enforceable. And that's a huge reliance on basically us being able to make a bare agreement and have it enforceable based on nothing more than the fact that we consented. We gave signs of that consent. So that's it's
very efficient.
And in France and in many, I think, continental Europe countries, you don't even need a napkin. I mean, the contract is consensual. It's just verba ligam homines. Verbal contracts are perfectly binding. Then there is a question of evidence, of course, that arises.
But that's only when there's breach or a problem, right?
Yeah. And that points out the question of education also, that I tried to refer to beforehand. If you're educated in a system where you are responsible where keeping your own words is something considered as good, and reneging on them is considered as bad, then you will have fewer litigation than in countries where words have no real value because there is no ethical constraints in this respect, and so you have to document everything.
Did you want to jump in on this?
Yes, you were saying
Please.
in order not to involve lawyers.
It's really important if you want to keep your money.
I would argue that to understand consent and what is really a contract, that it is not only a question of consent, you have to think also to very complex contracts. Otherwise, you do what Dworkin has said, you just look in the manual, something written in big lines. If you take in the merger and acquisition of big group of society, of corporation, with all the issues which are negotiated at the same time by different team of lawyers. I was involved with a tax clause of the contract relating to each of the company in each of the countries. And what is the discussion of lawyers to fix finally in the draft of the contract the correct clause? It's a discussion about what is reasonable. And at the end of the day, the owner decide just more or less the price and things like this, but otherwise the contract incorporate reasonable solution on a lot of different issues. So it's not so much a question of consent. The consent is given because it is reasonable, and it is not because the consent is given that it is reasonable.
I want to jump. This is one of your areas of great interest, actually, reasonableness.
Sure, yeah, no, I'll just add maybe that I think this is partly why Aristotle sees central kind of case of justice really to lie in friendship. So the most just relation is among friends, because they don't litigate against each other. That would be a form of distrust, and it would be the consequence of sort of betrayal. Whereas the unity is just and proportionate, and can be therefore a kind of paradigm case both of justice and friendship. Howard, do you want to?
Yeah, if I could say something. Fearlessly, foolishly, having not actually attended the previous discussion, this is what we're discussing. Strikes me that consent has benefits from two sides. So the idea of consent implies a relationship between two or more parties. So one is the liberty of justification that it helps me live my life more easily. The sort of utilitarian, instrumentalist reason that Jonathan's just. The other one though is, if I know that you've consented to something, that also helps me deal with you. It kind of helps me know how to deal with you, because I'm not in your head. I don't know what you really value. I don't know what is just in your mind. So if I want to treat you justly, I kind of have to be confident that you have consented to what I've done. In that sense that, in that way it's a proxy. I can't know what is truly just for you, but you probably have a better sense. Up to a limit where you hit something immoral. Like, obviously, the Cam case or something. But it helps me if I know you've consented to something to feel more confident that I've treated you fairly and justly.
Like Jonathan, this is still an extrinsic reason. This is not a reason to respect consent in itself, for itself. This is a reason why respecting consent makes society better.
But I think it's maybe slightly different, or maybe I'm just not thinking deeply enough about it, in that I can't know what is just in every situation.
Yeah.
And I can't know what is just for you, because what is just may involve things you value that I don't understand or don't know. But if I know you've consented, then I have more confidence that I'm treating you justly. I mean, it's a proxy maybe for justice in that sense.
Yeah.
Or at least a heuristic towards getting at something just.
Proxy for justice.
Yeah.
But at the risk of being stubborn.
Again, until you hit something immoral. Like,
yeah, but at the risk of being stubborn,
stubborn.
This is an epistemic claim. This is not saying that consent matters for itself. This is saying, hey, one of the things you get from consent is more
but I think
knowledge.
that's getting to the point where I will never know justice.
Yeah, yeah.
So this is the closest I can come to knowing
Yeah,
what justice
okay.
is. Being confident that you have consented with full knowledge.
Yeah.
I think I'm giving you justice.
It's an epistemic.
In your head as well as mine. 'Cause I can't get
In modern contract doctrine, though, by which I don't mean contract law, I mean the philosophy that tells us why contracts can be said to be binding ultimately. What's the glue? Consent is often appealed to, and the intrinsic value of it is that's where you finally get to the point where it's tacked to something else. That it's the tack that sticks it to something else. It's the glue. It's the thing. Say, what is the contract ultimately? It's an agreement. What sort of agreement? A consensual agreement between at least two parties. So you can't have a contract with yourself, for instance. You can't have a contract with a thing. You can't have a contract with an animal. So you need two or more persons who have come to a certain kind of understanding, which we talk about with the term consent, by which we mean two minds of these persons have agreed to bind themselves to do something at some future moment. And that binding we talk about as they've given their consent. So that's intrinsic. It's talking about it as that which makes
not
it.
intrinsic, but it's still a third extrinsic advantage.
But if it is the thing itself, how's it extrinsic? If it is
the benefit in question is in this case clarity, and that's clarity is a good, but it's not a good intrinsic to consent.
No, I'm arguing the good is contract, and consent is what we mean by contract, more or less, in modern law.
Contracts are paradigmatic of things that have no intrinsic value. The reason you have contracts is that you can bring about whatever you're trying to bring about with a contract.
Okay, here's the disagreement. I think the reason we have contracts is because we have to rely on other people's word, and which was brought up here, and promises. Otherwise, we can't have society with one another. We can't have certain kinds of relations with one another unless we have contract. That's why no human society that's ever existed has existed without something like contract. It might be called covenant sometimes. It might be called something else. That's why it's wherever you find humans, you find contract. It's as old as the Bible.
I think we're having a merely verbal dispute then, because I agree with that. Of course,
verbal. It's not merely verbal.
Of course, contracts are essential. You couldn't have a functioning society without them. I guess what I was hoping for was that someone would defend liberty. They would defend the notion that
Oh, I did that in my paper with Natural Liberty. Sorry, you had to get called out for your work, but yeah. Well, we did defend liberty earlier. Some of us didn't.
Okay. So
basically, you're looking for an argument explicitly premised on like the moral status of human beings being.
I'm looking for. I'm curious to see why no one wants to defend consent or make a weaker choice as a good that can compete with justice. And we all I think we all agree that there are times when justice must be limited, because the things you need to do to bring about that instance of justice would be manifest wildly unjust and on like a hugely totalitarian scale.
This was defended. Grotius does actually defend this. Far and away, liberty comes before justice, and the virtue that is needed then, for the person with liberty, is prudence. So prudence replaces many of the other virtues in one's dealing with others, because what it involves is me working myself out in my life out in the world in such a way that not to harm others, not to offend God, and to do as much as I can actually within that great realm of freedom and within the adiaphora, the indifferent things that are out there. And justice only comes to bear when there's breach or imbalance or something that, if I step too far, if I don't interact with the other with the care that an owner would of his own things. But with my own things, I can dispose of them as I please. I can even enslave myself. So there was a pretty thoroughgoing defense of Grotian liberty that was presented. And actually, Arnaud's talk also dealt with some of this in Pufendorf and others. So we can do that. Who's for liberty? David's for liberty. Go ahead, tell us.
Okay, it's just to let you know that Arnaud is back on there. So if you want to bring him in, he is there and can hear us and can turn on his camera and black.
Arnaud, we had a question for you, but the person asking it left. so we'll see if we can.
What do you think he might have asked?
Do you want to jump in on any of this, Arnaud?
We might have lost him again.
We might have lost him.
He sent a message saying that he was on, but.
Okay.
440 is what we're at. We have time for one more. We haven't heard from this section here. That Any questions or comments, or it can be a discussion point as well. Gosh, we settled everything. Conor Casey, now from the University of Surrey, is going to make some summary remarks for us.
John, how long would you like me to?
John,
sorry?
How long is Conor to speak?
Probably as long as you want, or 15 minutes.
We'll see how it goes. Which of those are the terminus point? So I want to say that I really am honoured to be asked to give some summary comments on today's colloquium. It's always a joy to be up here at Pusey House. I must however begin by begging your pardon and patience, because as a humble constitutional lawyer with a smattering of jurisprudential learning, I'm aware I am truly straining every fibre of my professional competence, engaging with the rich array of philosophical, ethical, moral and theological insights offered by our commentators. I also beg pardon because this is very much extempore. There were no papers circulated before, so if you will extend some patience because of that. I want to offer some thoughts grouped around the idea that this colloquium and the wonderful journal initiative it is attached to showcases the variety of ways the natural law tradition continues to offer a powerful tonic to some of our current legal and political maladies, many of which stem from a rejection of the tradition's truths and insights. So we'll begin first. Malady it provides a tonic for is the nature of political authority. Politicians and
political parties today tend to be strikingly unreflective about the nature and justification of political authority, insofar as they do offer answers about why political authority is legitimate. They might appeal to popular will or democratic pedigree behind the decision. More ambitiously, some politicians might venture into offering a social contractarian type of justification. The political authority is a necessary evil that we endure for the sake of avoiding a greater suffering. It is a mutual insurance pact sort of arrangement to avoid the worst cruelties of human nature. But as Clemente and Dominic remind us, the natural law tradition offers a much richer account of the point and purpose of political authority. So this is not an account motivated by fear or sub-rational passions, but from reason and reflection on the very great goods that only political authority can secure. So political authority on this account, as Dominic and Clemente outlined, is not an artificial social construct, because man is by nature meant to live in society. In the first instance, by nature and reason, we're inclined to live before family, the family that begets us, nurtures us, and to a certain extent educates us. But to live a fully human and flourishing life in community will include type of circumstances and conditions that individuals, families, and even groups of families cannot secure, like peace and order, provision of sufficient economic and material goods, or even the fostering of higher spiritual or cultural qualities by which human life is truly made human. So the purpose, the justification, and limitations on political authority in this tradition, in the natural law tradition, all connect back to its ability to uphold the political common good and contribute to the all-round flourishing of people living in community. So Clemente correctly reminds us, therefore, that it's not popular will that confers political authority, but Aquinas did say that the regime with democratic elements commends itself to all and is most enduring. It is not majority will or majority consent that confers legitimate authority. Rather, a political entity has presumptive authority where it has the capacity to order persons to the common good and has a steady orientation to doing so. One flip side of Clemente's observations, I think, and it's not remarked upon enough, is that it offers a potent reminder that the people, majority, have no right to do wrong. And a profoundly unjust law remains more akin to violence in the conscientious deliberations of citizens and officials, even if endorsed by a majority. Clemente's articulation of an orthodox account of political authority reminded me of my beloved Irish Constitution, which was enacted in 1937. Don't be surprised if we're going to try and tie everything back to constitutional law. So the Irish Constitution's preamble opens with the ringing declaration that all authority comes from the most holy Trinity, to whom all actions, both of men and states, must be referred. This orthodox account is also captured by Article 6 of the Irish Constitution, which provides that all powers of government derive under God from the people. In other words, political authority does not come directly from the popular will, but is a requirement of natural law. It is a requirement of satisfying our practical reasoning at full stretch. It's a critical aspect of our individual and communal well-being. Without political authority and the protective, the coordinative, and educative function it plays, we just cannot flourish as individuals or in community as a kind of rational political animals we are. Dominic's remarks in particular reminded me about how careful we have to be in talking about the common good, however, especially in today's political world, which has lost fluency or familiarity with much of the classical tradition's terminology. We do not want to give the impression that the common good is an end state that we can arrive at once and for all. And we need to be very clear in stressing that the common good is not the good of the majority, merely the majority rather, or a collective good somehow separate from the good of individuals. Common good is the good of flesh and blood persons living in community together. It's not an abstract end goal separate from them. As such, it's a good that can only be maintained or instantiated through a highly complex web of relationships, transactions, and undertakings, all underpinned not only by law, as Dominic alludes to, but also by things like custom, morality, virtue, and ultimately love. Because a society where parents are only just towards their children, or friends are only just towards each other, would be a very impoverished one. There needs to be virtue, there needs to be charity and love as well. So that's the first collection of thoughts. Second, concern the inherent normativity of legal reasoning. So I think another valuable contribution made by the Colloquium today. It's this reminder of the fact we cannot and should not want to expunge moral reasoning from legal reasoning. And this is something even many natural lawyers, particularly in the United States, wish to do, to expunge moral reasoning from adjudication. But I think this is mistaken. Henri's remarks made me reflect on the fact that legal reasoning by a well-functioning judicial body will be inescapably normative. That is to say, legal reasoning aimed at justly resolving a dispute cannot rely merely on social historical sources or facts in a way that's decoupled from insights into the principal moral purposes for which law is made and applied, like promoting justice and the common good. In sound legal reasoning, the artificial reason of law and principles of natural law stemming from practical reason will run concurrently. And what I think is really interesting is that even judges today who disclaim any reliance on the natural law will still frequently bring to bear some of its basic precepts when interpreting positive law. And I think one can see this, for instance, when judges approach interpretation armed. They approach interpretation, let's say they're trying to find the meaning of an enactment or the intent of the lawmaker. They do so armed to the teeth with a very rich set of axioms and presumptions that often have a decidedly shaky basis in social fact sources. So consider the following axioms and presumptions that I thought about. You may find in many legal systems, UK, Ireland, Canada, likely. The presumption that positive law is not intended to bring about absurd consequences, but aims for some rational purpose. The presumption that no one will be a judge in their own cause, that those affected by a decision will be heard, that no one will profit from their own wrongdoing, that retroactivity, especially criminal, is not favoured, that penal statutes where ambiguous will be interpreted to avoid imposing criminal liability, that settled legal claims will not be litigated, res judicata, that every right will have a remedy, and so forth. Judges in these type of legal systems, they do not regard these kind of principles as moral norms that are external to the law, but as legal principles that are part of its fabric, and critical to interpretation and to resolving disputes justly. And these legal principles, as mentioned, just often don't have a positive law source prior to being invoked. They're invoked to help construe positive law because of their appropriateness in helping to resolve a dispute justly, while keeping the legal system directed towards its proper end of justice, peace, and the public good. I was reminded of Professor Richard Helms of the University of Chicago, who pointed out that in the history of the jus commune and the common law traditions, judges and lawyers just took it for granted for much of Western legal history that legal ordinances could not have been intended to reach an absurd or iniquitous result. So this is just the pattern of their legal practice would be to involve reading positive law in light of natural law precepts. And I think this might have been going on, that fascinating example offered by, I think it was you, Jonathan, where Roman law stressed that laws concerning slavery, which was acknowledged to be contrary to natural law, were to be construed strictly against continuing the enslavement, which is contrary to natural law, and in an expansive fashion in favour of freedom consistent with it. So the presumption at play here was that positive law should do their best to avoid contradicting natural law. So I think today was a valuable reminder of that. So the third and final malady I think today touched upon was that it provided a nice corrective or a counter to the kind of extremely influential but impoverished understanding of the nature of freedom and autonomy that pervades and predominates political and legal thinking today. So Jonathan Sébastien Neuville spoke about freedom and self-direction. I have to say I find these talks the most difficult to comment on, as they truly do involve material so far away from my competence, but two thoughts came to mind. So the first is just as an observational matter, how architectonic the idea of freedom and choice are to our legal systems. Legal concepts like responsibility, duty, fault, liability, mercy, all collapse unless we anchor them on the idea that we are rational animals, able to intend and able to choose different ends and goods. And if we as a society abandon sincere belief in this idea, I just can't see how we can justify these concepts and the obligations and duties they impose on persons without telling and living by an enormous lie. I don't know how we endure without them. The second thought was that the natural law tradition and its account of freedom, as outlined, by Jonathan Eyal is that it poses existential challenge, a serious and existential, dangerous challenge to dominant contemporary Western concepts of freedom, because, like it or not, many citizens and politicians would readily endorse the infamous dictum. I think it's infamous of former Supreme Court Justice Anthony Kennedy in the Casey and Planned Parenthood decision, where he said that the proper reach of state power ought to be cabined by the ideal that, quote, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. And I think there is today a form of liberalism whose master commitment really is to this idea of autonomy of the individual, of the reason and desires. And I think this understanding saturates most areas of public life, and it plays a very prominent role, justificatory role, when it comes to domains like legislative action, constitutional doctrine, and human rights law. I think that, to conclude, the fact that the natural law tradition emphatically rejects this picture of liberty makes it a profoundly radical and doubtless to many today a dangerous one. But I think that is partly why it's more important than ever to defend the idea that our real freedom lies in following the natural law and pursuing the good life. Thank you.
Conor, we should do that every time. Actually, if you wouldn't mind sharing that with us, we might use it as a record of some of what was said for the day, and we can pass it around if you consent.
Oh yeah.
Yes. Then we can pass it around, or even if you don't. Yeah, even if you don't, I'll consent on your behalf. Now, we'd like to thank you all for coming today. We do these colloquia 2 or 3 times a term. On your way out or back in, if you're joining us for dinner, I'd encourage you to get one of our term cards, which includes worship services and other things, or one of our lecture and conferences term cards. But for now, I'll direct your attention to something that's coming up next week on Wednesday, and that's David Engels. Professor David Engels from Brussels is asking whether universal history is possible. Good question. I think he thinks yes. But how and in what way? Jane Cooper, who was here with us earlier on the 29th of May, will talk about piety and polemic, the paradox of Elizabethan satire. And she's a friend of the house who's a fellow at All Souls College. And finally, Joan Lockwood O'Donovan will talk about the public authority of the Church of England, the theological foundations of it, which is actually part of a larger conference with the MacDonald Centre at Christ Church about the public legitimacy of the Christian faith, really. And that will be on the Monday the 10th of June is, Monday the 10th of June is the conference. If you want to know more about that, email us at pusey.conference, which you've been corresponding with us at. She's speaking, though, on Wednesday the 12th of June, and all of those lectures are at 4 p.m. in the chapel here, or in this room, depending on what size of crowd we're expecting. That being said, we're happy to cooperate with you or with others on future endeavors. If your college or your institution, or in this case a journal, it's our first cooperation actually with a scholarly journal, very happy to do it. We need about a 6-month to a year lead time in order to do it well and get the funding together and get the right people in the room. So please come to us and tell us if you'd like to cooperate again. Obviously, you want to do it again, or if other organizations would like to. We're going to cooperate next year with, looks like with Blackfriars to do at the Las Casas Institute to do something on the meaning of money. That's in the works. So another fruitful cooperation. Yeah, it's the first he's heard of it, but no. second. So I thought I'd just enforce it in this setting. So thank you very much for being here. If you're coming back for dinner, well, 2 things. So we have evening prayer here, which is quite an ecumenical way to pray together, and it's a self-sung service, as it were. So you are the song, yes. Didn't know that, but you are the song. That's at 5:20, so just in 30 minutes' time. If those who didn't get a chance to ascend Pusey Tower because Group B wasn't there when I came back for them, I can take you up just after this. There is Anglican Mass at 6 here. If you would like Roman Catholic Mass, Blackfriars is 6:15.
6 o'clock.
6 o'clock. 6 o'clock is just out the front door and to the right. We have a drinks reception for those coming to dinner at 7. That will be in the quad here, and then dinner in the hood room. Jacket and tie, it's not really a code, it's more like it's reasonable. It's a reasonable request. So if you need a tie or something, we can loan you one. Jackets are harder. But, you know, we'll let you in. The seating chart is here. You can inspect on your way out, so you'll know where to go. And with that having been said, are there any other questions? Oh, I have one. You would like to publish the papers from this.
Yeah.
What's the timeline for its translation and
It's
other
from the
things?
second zero, so it's we will publish it in 5 months. So we need the papers in
2
months.
So will you be in contact with them, or will Pierre
The better is with Pierre.
Pierre, okay.
Yeah.
So you
And all the paper will be read again by 2 persons without.
Yeah, I understand.
So it's
it's
not
peer reviewed. It's a
you
peer
are not
reviewed
necessarily
process.
published.
It's a peer reviewed process. Great. Double blind. The blind leading the blind. Scholarship, as we call it. Right. Thank you so much for your time and attention. We hope to see you here again really soon. So.
Thank you.